User partnered applications and appeals in the matter of Pfizer and Flynn Pharma and the CMA.
My Lords, three short points in the 15 or so minutes this morning. Can I start with, there's been considerable discussion over the last 2 days about the adequacy of the CAT's reasoning in relation to various points before it, and the CMA's ability to pass findings of fact and expert evidence in this appeal. And in my submission, it's important to recall what are a very clear set of principles governing appeals of this kind. If I can just quickly hand up a passage from the Volpe case, which my Lord Justice Snowden will be familiar with. I think the court should have received copies overnight. It should be in tab 2 of a separate bundle. Lord, have that? Thank you. So very quickly, paragraph 2. 1, an appeal court should not interfere with trial judge's conclusion of primary facts unless it is satisfied he was plainly wrong. 2, plainly does not refer to the degree of confidence felt by the appeal court that they wouldn't reach the same conclusions as trial judge. It does not matter with whatever degree of certainty that the appeal court considers they would have reached a different conclusion. What matters is whether the decision under appeal is one that no reasonable judge could have reached. 3, very important, an appeal court is bound, unless there is a compelling reason to the contrary, to assume that the trial judge has taken into account the whole of the evidence in consideration. The mere fact that the judge does not mention a specific piece of evidence does not mean he has overlooked it. Then 4, trial judge must of course consider all material evidence before him, though it need not all be discussed in his judgment. Weight primarily matters to him. And 5, again, more on plainly, only if the judge's conclusion was rationally insupportable. And 6, in my submission, is very important in view of the CMA submissions. Reasons for judgment will always be capable of having been better expressed. The appeal court should not subject the judgment to narrow textual analysis, nor should be picked over and construed as if it were a piece of legislation or a contract. And then 4, similar caution applies to a trial judge's evaluation of the expert evidence. And Roman 5, we then go to the end of paragraph 65, where the judge, Lord Justice Lewison, wraps up the very last page. Under 65, Roman 5, it concentrates on particular verbal expressions that the judge used rather than engaging with the substance of his findings. And then he re-emphasizes 66, rationally insupportable. 3 very quick points on the back of that, if I may. First, to the extent the CMA is seeking to go behind findings of fact, they have to show they are plainly wrong or rationally insupportable. In other words, no reasonable judge could have reached that conclusion. And in relation to the key areas of fact found in the set-aside decision, the medical evidence, the GT price, avoided costs, tablets, other ADs, and cost plus, the CMA, in my respectful submission, is a million miles away from meeting the plainly insupportable standard. And I would go further. In truth, if one examines the substance of their appeal, they do not even challenge the key findings of fact, never mind giving a proper basis for saying why they're said to be plainly wrong. Secondly, the suggestion that the judgment failed to grapple at all with certain points is wrong, we say, on at least 2 levels. First, it is wrong at the level of principle. As I showed your lordships in Volpe, an appeal court is bound, unless there is a compelling reason, to assume that the trial judge has taken into account the whole of the evidence, even if he doesn't refer to each and every item. And this textual, the statutory or contract approach is to be deprecated. Now, as your lordships are aware, the judgment in these proceedings is extremely long, 316 pages, on the back of a 500-page decision, a bundle of documents comprising, I think, several thousand, if not more than 10,000 pages. And in my respectful submission, in the real world, the judge cannot be fairly criticized for failing to address every point or it should not be presumed that it failed to take it into account. And the kinds of forensic darts which have been thrown by the CMA, in my submission, are the wrong approach in principle. But more importantly, and this is the crux of it, it is in my submission, on a very cursory analysis, an untenable review of the judgment under appeal.
Can I ask you this, in relation to the retaken decision, do you accept, is it your view that the CAT got the facts right and therefore correctly came to the conclusion that on the facts the differential was grotesque?
As I said yesterday, I don't want to go down this rabbit hole again. The critical thing to understand about the remade decision is that it is using a completely different lens. And that is why things that were found relevant and material in the set-aside part do not feature in the remake part. But I don't want to go back into...
No, but there is an inconsistency. I mean, the lens turned out to be favourable to you because it gave you the advantage of medical benefit and various other things, and it...
Well, it didn't. So
well, I know you disagree with that, but I mean...
Well, my lord, it's very important. So
certain amount of cake is...
The avoided costs were not taken into account. The DT price was not taken into account. Yeah. The medical benefits other than psychological were not taken into account. So a whole raft of things that were the basis for the set-aside, because of this lens, were written out of the equation. So we say one is comparing apples and compotes. It is a completely different lens. Now, on the judgment itself, the CMA's positive case was on the 6 factors. And as we saw in the judgment 215, the CAT went through each and every one of the 6 factors in the decision and explained why they were misguided. And it isn't seriously suggested before your lordships that there is a misreading in that part of the judgment. One sees the 6 factors listed and the reasons. So where Mr. Holmes really focuses his fire, he says, well, when they get to the second part, unfair when compared, there is a complete disregarding of aspects of the CMA's case in the decision. But in my submission, again, on a very, very cursory analysis, that is a plain misreading of the decision. Now, I don't have time to go through each and every comparable, but let me take the high watermark of Mr. Holmes' case, which is on the drug tariff and the tablet ASPs. We start with the drug tariff. If we go to 253 of the judgment, it's an 860 of the of 432, 935 electronic.
So did I hear you correctly? 935 electronic.
Lord, yes.
Just before we get there, can I just, do you accept that the part of Volpe that we're really focusing on in this case is not so much findings of primary fact, but of evaluation of expert evidence?
Well, we say it's both. So, for example, my lord, the medical evidence would be a good example. There are aspects of that that are medical expertise. There are aspects of that which are factual. The drug tariff is another example. We say the CAT found as a fact that how is the CAT making a determination as to which of the medical evidence or what of the medical evidence it should take into account? Finding a primary fact, I mean, isn't that preeminently a question of evaluation of medical evidence? Well, Lord, for example, the side effects, is there side effect X of drug Y? That, in my submission,
yeah, but that's been done on the basis.
Question of fact.
I mean, that's been done on the basis of expert evidence. I mean, the sort of primary fact we were talking about that I think that Lord Justice Lewison was talking about in Volpe is sort of where there is a question: did X do this on such and such a day? His
yes.
That said he did. And
yes, the 4 million Swiss francs payment. So we say it's both. So perhaps a good example would be the drug tariff. The CAT found as a primary fact that the department threatened to use its statutory price control powers to achieve the £30 price. That is a question of primary fact. That would be one example. So we say it's both.
So some of both, okay.
Yes.
The other question is just a simple one. I mean, the comments that the Lord Justice Lewison makes about reasons being capable of being better expressed. So I'm not here talking about the question about whether a judge is presumed to have taken into account all relevant evidence, but how it's expressed, you have a range, don't you, from extempore judgments, which is very much the Piglowski type authority that's referred to, and then you have reserved judgments, fairly lengthy and considered reserved judgments. I mean, is the court entitled to take a slightly more analytical approach to the way that things are said in a extensive reserved judgment?
Well, in my submission, yes. But of course, there are other layers to the onion. One, of course, is that it's the combination of a long trial, and not everything can be replayed in the judgment.
I appreciate it. This isn't the question about taking every point.
Yes.
I think there were far too many points. Far too many points kicking around in these cases, if I may respectfully say.
Yes.
As an sort of outsider being dragged into them.
Screaming.
Behind the scenes. But when you're dealing with technical reserved judgments of this type, it's not a statute. We're not construing it like a statute, but we are entitled, I think, to look quite closely, are we not?
Yes, but there is a spectrum. I accept that.
Okay.
And of course, but the other composite point, my lord, is it is important to look at the substance of the findings, not stray words here and there. And in my submission, the flaw in the CMA submissions is they're looking at the wrong end of the telescope. They're not attacking the substance, they're attacking sentences here and there. Okay. Now, just to make that point good, starting with the DT 253, so you'll see from the heading of the section, it says the CMA's position as stated in the decision. So that's what this section is about. And it then sets it out. And then if we go over the page, it says we turn to the reasons deployed by the CMA for rejecting the drug tariff as a comparator. And then you'd see in the footnotes references to the decision. And then it goes through the reasons, dismissing each and every one of them. Now, on the ASPs, in my respectful submission, the same conceit is deployed by the CMA. Mr. Holmes complained that the CMA wrongly misunderstood the decision when it found the tablet ASPs were left out of all consideration. That is an unfair reading of the judgment. Again, there's a whole section of the judgment on this. We start at 263, which is on page 867, 942.
Sorry, para.
263, my lord. Again, a whole section of the ASPs. And then over the page, my lord, you see the diagram. They set out the 4 periods. And you see, for example, my lord, in the second period, the duopoly. So they've set out the 4 periods in graphical form. And then at 266 at the bottom of the page, the CAT deals with, and I quote, the reasons the CMA gave for taking no account of the tablet prices. And again, as with the DT, you see a reference to the paragraphs of the decision in footnote 413. The CAT then proceeds to analyse the 4 periods in the tablet market, and its basic conclusion is that it disagrees with the conclusions the CMA drew in the decision in relation to what the pricing and switching data shows about the levels of competition. So it is simply wrong to say the CAT did not deal with the CMA's case in the decision. It did, and it made factual findings, which I reiterate are not even challenged in these proceedings in relation to the data. And in my respectful submission, it is, to put it mildly, an ambitious submission to suggest that this judgment fails to pass the Volpe standards.
Well, just out of interest, in 2671, was the CMA actually introducing a new test?
Ms. Stratford says she will deal with that. I think the answer is no. But she will deal with that.
I hope we haven't entirely stolen her thunder then.
Yeah, yes. I'll leave it to Ms. Stratford. Far better to deal with that.
He's basically saying it is the test.
Yes. Yes. The short answer is basically saying that it is the test. Penultimate point, I'm going to hand over to Ms. Stratford very quickly. The quality of life adjusted years, the quality respondents notice point. Now, I have been compressed for a variety of reasons, but it is very, very important in my submission that this point is not treated as an afterthought in these proceedings. It is fundamental. I will not have time to develop this with anything like the depth I would hope. Let me give you the basic essential points that we say are critical. This is really for your Lordship's context. I mean, there is a rich backdrop to what the quality comprises and how it fits in the policy scheme. And I think that the best place to locate that, if one looks at our written closings in the CAT, it's at supplemental 15, 1022.
Supplemental 15 or 50?
15, my lord.
15.
At 15. It's volume 2. Let me very quickly give you a sort of thumbnail sketch of the terrain. So we start at the bottom of at 230. We give the context here. So in the first CAT judgment, look over the page, they said placing a precise monetary value on patient benefit is not straightforward, and they encourage the CMA to do what it could. And you'll then see at 232, Derek Ridyard, who was then Pfizer's expert, is now a CAT wing member. He did, in his evidence, mention the concept of quality, but he candidly accepted that health economics and antitrust economics are different disciplines. So he did mention that there is a metric out there being used in the real world for valuation purposes. We then, picking up on the comments of this court in liothyronine, that if you want to assert a benefit, you have to put forward evidence of that benefit and its materiality. So we instructed a health economist, Dr. Schedule, to perform a quality analysis. And then you see at 234, there is a reasonably fulsome description of the history of quality. You see, for example, at 235, it was a key metric used in the context of COVID-19, which medications to fund. 236, it has been a great intellectual export by this jurisdiction, major international influence, in different jurisdictions. Quality has been exported all around the world as a key metric for assessing medical cost.
We've seen some of this, we've seen references. Can I ask a question which interests us? Which is this, that a really central issue in this case is the extent to which medical evidence, one, is quantified as benefit, two, then translates into value.
Yes.
When Scheme M applies, there is an underlying premise that the market is competitive, so
Yes,
that the
competition will do its thing.
competition deals with it.
Yeah.
When you've got an undertaking that's dominant, that premise doesn't necessarily work. What we don't have from government, and I know the department didn't give evidence, is any indication of how it values things such as costs saved by medicine,
Yes.
broad and what might describe as macro considerations.
Yes.
And at that level, because the concept of fairness is so vague, what the government policy is on on both identification of a benefit and valuation could be something that the competition authority would take into account. I'm not certain it's necessarily always a distinct analysis, because the test of fairness is, as we just said elsewhere, it's quite protean.
It's open-ended. Nothing necessarily in or out.
It may be that you take into account there's still headroom between that and average selling price,
Yes.
but at the
Well,
margin,
there's a question of weighting.
question of weight. And
Well,
so we're not saying that the view of the department is irrelevant. They are a buyer, they're government, they set policy, and what they say about policy might have a bearing upon both identification of a benefit and the way in which it's valued. You could have the department saying for these sorts of drugs where the cost avoided is, in our estimation, the strain of X, we will permit X% above cost plus.
Yes.
We don't have that considered view of government in a case such as this.
Yes. Well, Lord, can I quickly make a handful of points? First of all, as Mr. Greeley said yesterday, for the second occasion, for reasons which were not explained, the Department of Health was entirely absent from these proceedings. And it is unsatisfactory, to say the least, that they are on the one hand sotto voce complaining and then unwilling to come forward when the drug tariff, the quality, and their own policies are at the centre of the case. That is unsatisfactory.
It may just be that they just don't systemically, organisationally address themselves to how you price generic drugs where there's market power. Well, because that's not an assumption which runs through the department at all.
What one doesn't know. Now, secondly, my lord, on the policy question, I mean, we would say that this may well be a unique situation in the following sense. I mean, the Department of Health is in a highly unusual, I think, unique position because they're the customer, the underwriter, the regulator, and effectively the legislature. And as Mr. Johnson will come on to later, one of the consequences on the legislative side is that they perceived, we say wrongly, there was a gap in price control powers, and they sought and obtained very quickly new legislation to plug.
They're not the legislature, they're the enforcer. They're the regulatory.
Well, they can lobby very directly to obtain further legislative powers. Now, in that, we say unique, certainly unusual context, in my submission, it is plain as a pikestaff that the policy views, the different mechanisms of evaluation attached by the department to this drug or drugs of its kind are absolutely on the money. Indeed, it would be highly obtuse in my submission to say, well, what's that got to do with the price of milk? It's central. Now, finally, my lord, and this really...
But I mean, let's assume we agreed with that in principle.
Yes.
There is a gap in the government expressing policy about how it identifies benefit and values it in relation to generic products where there's market power.
Well, that is the crux of the quality point. Quality is...
We get that.
Quality is the best metric for plugging that gap because it is the only metric which seeks to nest the relative and absolute therapeutic benefits of the drug on the one hand and the cost savings on the other. And in a way, it is a significant upgrade on the medical evidence because we had two very eminent experts and they were extremely useful. But what the quality does, it does two things. It is essentially a meta-study of therapeutic benefits. So it is sort of the experts of experts because one of the inputs is you will do as best you can, a global meta-survey of all of the evidence out there in peer-reviewed journals on the therapeutic effects of different drugs. And then secondly, it is not simply therapeutic, that is melded with cost-benefit considerations, cost savings. So it is the only metric out there which, in quantitative and statistical terms, seeks to put a number on these benefits. And what we find with respect...
We understand that. We've got all that. The difficulty is we don't have the government's stamp on it, saying this is how we interpret it in a market where there's market power.
Well, my lord, we did all we reasonably could.
I understand.
Which is we instructed a leading health economist. He replicated the quality assessment conducted by NICE as best he could in the circumstances. So we say we have introduced a very, very strong proxy for exactly what NICE would do in relation to this drug. And on the face of it, it is an extremely compelling piece of evidence. And for the CAT to say, and I quote, we get nothing from the quality as a matter of principle, it is an astonishing conclusion.
So the CAT, the CMA?
Well, both. If we can quickly look at the judgment. It's a 274-275, it's core 32-874.
Oh, yes. Yeah.
So, well, you're right. The CMA says, well, why on earth do we want to look at quality? They didn't bother. And then the CAT, with respect on this point, is all over the shop. So they say at 274, this evidence would cost benefit.
Sorry, I've just lost where you are.
Forgive me, my lord. It's 274 CAT judgment. I think it's 948 electronic.
Sorry, that's what I didn't get. 948.
Yes. So they say this evidence with the cost-benefit analysis, which is undoubtedly related, to be in fairness, Lynn, self-evidently, if the benefit exceeds the price charged, cost here, the paying part of the NHS, then the argument in favour of fairness is strong. Now, if one stopped there, you would think, well, we're home and dry. And then they go on to say, we can draw nothing from the fact it's been approved prescription, NICE evaluation will be part of the armoury, although NICE is not the price we pay for capsules or tablets. Then the next paragraph would be wrong, it seems in principle, to import the public health processes that govern the availability of drugs in the UK, what is a competition law assessment of whether a price is unfair, and then bizarrely it says doubtless the same factors, cost of production, price, benefit, patient, will pertain. And what we do not understand is how can the CAT on the one hand say, well, the policy objectives underpinning the drug tariff of £30, they're relevant to material, but then the quantitative metric, which is the quality, that it tells you nothing. It is wrong for two reasons. One is inconsistent, but two, it ignores what in my submission is the most important quantitative manifestation of policy. And three, as a matter of law, as my Lord Justice Green said, the correct approach in law is inclusivity and weighting. The correct approach in law is not to say, well, as a matter of principle, this goes in the bin. It tells you nothing. So unlike the errors put forward by the CMA, which are at best challenging the weighting of evidence, this is a point of principle that the quality, they say, tells you nothing about the economic value of phenytoin sodium. We say that is an extreme conclusion, it is an inconsistent conclusion, and it is wrong in law. So there's a lot more I could say on quality. I'm afraid I don't have time. My final point in about 2 minutes is where does all this take us? The tone and thrust of much of what your lordships heard from the CMA is, well, don't worry, just restore the decision. And I want to close by stressing in the strongest possible terms why that would be the wrong approach. The decision has been found to be seriously and irremediably flawed. It got the facts wrong time and time again on dispositive and critical issues of fact and expert evaluation that go to the heart of this appeal, such as what is the drug like, the count of comparators, prices above cost, avoided costs, the drug tariff, and so on. The CMA has lost on the facts and on expert determinations, and it cannot escape those salient points on appeal. I've just addressed you in the quality evidence. That was compelling, it was quantitative, unlike every other metric in this case. It was specific, and it went to the heart of this appeal, since it is the only metric in this case which melds costs and benefits using a quantitative and statistical threshold that the department itself routinely uses for value purposes. That is also why the CMA decision cannot be simply reinstated. The quality was not considered at all by either the CMA or the CAT. And in my respectful submission, it would be a travesty to tell our clients that they basically won at trial on all of the key points they argued, that based on your lordship's provisional indication, the remade decision should be set aside, but they are now lumbered with a £63 million fine, a finding of infringement, unavoidable consequence of follow-on damages, and potentially disqualification of directors. And we say it cannot be right or fair, and there's no respectable scenario, we say, in which the deeply flawed CMA decision in this case should be restored. If the remade decision is set aside, it will be the fourth time our clients have succeeded in these proceedings. And the fact that this vista is even being suggested by the CMA, 14 years after these proceedings first commenced, is itself an astonishing statement. It is high time, we say, to bring things to a close. It would be oppressive not to do so.
My Lords, on behalf of Flynn, we're most grateful to Mr. Brealey and Mr. O'Donoghue for addressing your Lordships on a number of matters which are also relevant to Flynn, and we gratefully adopt those submissions. And of course, in what follows, we will strive to avoid any duplication. And before coming to a roadmap of what I and also Mr. Pascoe will address your Lordships on during the time we have, I want to just take a momentary step back and begin with 5 bigger picture points. First, and I deliberately address this first and head on, the so-called price spike. Now, of course, the price of phenytoin increased significantly following the grant of a license to Flynn in 2012 and the medicine's exit from the PPRS. It stopped making a loss and a new price was set. That's why we're all here, and your lordships may think disappointingly back here after the court's 2020 judgment. Now, as far as Flynn is concerned, there was no before price. It hadn't previously sold phenytoin. But of particular legal significance, the fact that there was a price increase, and a notable one, doesn't answer, of course, the questions with which this court is faced. And the then Chancellor put that, in my respectful submission, particularly well in the introduction to his discussion of the issues in the 2020 judgment. Its passage, you've, of course, already been shown, and I won't go back to it. But he observed that the price increase, and I quote, did not abrogate the need for a rigorous, reasoned approach to the legal and factual questions before the CAT. Albeit, of course, he said, the increase was important to keep in mind. Now, the CMA are understandably ensuring that the price increase remains at the forefront. Their written arguments are peppered with references to it, and we heard more of the same, particularly from Mr. Holmes yesterday. But, Tuesday. Seems a long time ago. But whilst that, it's all understandable from an advocacy and forensic point of view, we submit it shouldn't be allowed to become a distraction from the real issues with which this court is faced. So vague, eye-catching references to price rises or even absolute returns do not provide the rigour that the court needs in this field. So we do submit it can't be a finger in the air, wholly discretionary test. The law mandates properly circumscribed tests for a number of reasons, including, of course, legal certainty, as this court stressed in liothyronine. That's paragraph 202 of liothyronine, which I won't go back to. Now, the court may fairly think the 2020 judgment went to great lengths to set out the applicable principles, the test to be applied in as clear terms as possible, and all the parties needed to do was act on what the court had set out. Matters should have been resolved. And the frustration that hasn't occurred is fully acknowledged. The frustration is particularly great on the part of my clients, Flynn, an SME whose business has, for all practical purposes, been unable to move forward for the past 12 years with the looming shadow of uncertainty cast by these proceedings. Now, I can assure you the directors of Flynn do not engage in litigation willingly, let alone the costs of litigation. And that does bring me to my second point, which is the distinctions, we say important distinctions, between this case and some of the other pharmaceutical excessive pricing cases which have recently been before this court and the tribunal. Liothyronine, of course, just for the note, at Authorities, Volume 3, Tab 57, and hydrocortisone at Authorities, Volume 2, Tab 53, which, of course, is listed before this court on the excessive pricing appeal for the end of June, I understand. To flag just one way, we say those cases are very different. The differentials between cost and price, i.e. the profit margin, were of a completely different order. So in this case, they were on average across all four strengths and over the whole of the relevant period, 47%. in liothyronine, as your lordships know better than me, they ranged from 900% to 2,500%. In hydrocortisone, the differentials were from 550% to an even higher 2,750%. Now, Mr. Pascoe will come back to this, and I don't want to get into the detail.
In some cases in the far end. Anyway.
You have the point, my lord. It is one of the reasons why the arguments which the companies deployed in those cases were quite different from some of the submissions available to Flynn on excessiveness here. And just while I'm on distinctions, if I could say something very short about the differences and connections between Flynn and Pfizer's appeals, and it feeds through also into our different focus in responding to the CMA's appeal. Flynn's appeal differs from that of Pfizer because it purchased from Pfizer at a particular price and added a margin that was consistent with the margin that it adds to its other products. So the focus of our appeal was, before the CAT, was on the excessiveness limb. But, of course, to the extent that Pfizer succeeds on the unfairness limb, we say we're entitled to benefit from that too.
So the 47% figure was Flynn's?
Yeah. The third big picture point is this. The CMA's application for permission to appeal seeks to appeal an order following a 6-week trial which included around 11 days of evidence, both factual and expert. The judgment rightly acknowledges that the expert evidence in this case was extensive. For your note, that's paragraph 43 of the judgment, which I think Mr. Brearley showed you briefly yesterday. Now, I know that this court is acutely aware of the dangers in such situations of what has been referred to as island hopping. And in light of what Mr. O'Donoghue said on this morning, I'll take it very shortly. But we do want to stress that the CMA's appeal does suffer acutely from island hopping. And to meet directly my Lord Justice Green's point about cakeism, we don't accept that this is a case of that. Whereas our and Pfizer's appeals against the tribunal's remade decision challenges a novel construct of the tribunal, and so necessarily was not the subject of grounds of appeal or evidence below. The same is absolutely not true of the CMA's appeal against Part 1. So they really are very different targets, my lords. Just one short point, and not, again, I'm afraid, for reasons of time, not to develop now, but in response to the exchanges with my Lord Justice Snowden this morning about the approach taken to evaluative assessments and findings of fact, I would just refer to the judgment in Bulb, the Bulb litigation, which my Lord Justice Zacaroli is particularly familiar with. Paragraph 107 there says that the same approach should be taken to, in this regard, to both types of assessment. And apparently,
I mean, I don't think that's
okay.
I mean, Volpe itself said it's a similar approach. It's just that I think it's very different if you have an extempore judgment, for example, and if you have a lengthy reserve judgment.
Yes.
I think that was really the point I was trying to make. And then you have a different approach again where the court, for example, hears live oral evidence and has to decide, was X, the person who was in the car at the time.
Yep.
Or where you're hearing, for example, a series of expert evidence and you have to reach some sort of evaluative.
Yes. There was
to who is, what the preponderance of expert evidence is on a particular point.
There was some factual evidence as well, my lord, as your lordship knows. Particularly one of the directors of Flynn, Mr. Fakes, escape evidence. Now,
Can I just ask a question? So this was a judgment of 3 judges, reserved, and they had a referendar legal secretary to assist them?
yes.
It's not an unconsidered judgment.
No, absolutely not. That wasn't what I was intending to suggest. But Mr. Bailey and Mr. Holmes did at various points take your lordships to carefully selected, no doubt, paragraphs of the judgment, chosen passages from the decision, even graphs, your lordships will recall, the few were scattered in, all very skillfully constructed, very elegant. But the fact remains that this was a merits appeal, not a JR. We had detailed both written and oral evidence. Now, we're all in awe of my Lord Justice Green, or at least I am, for having read so much of the second decision, and that's plain. I dread to think what your Christmas was like, my lord. But the fact remains that this is not the trial. We have had a trial. And with the greatest respect, this court should not be lured by the CMA to go beyond
we won't.
territory.
We're very conscious of our limitations. I mean, it's constitutional and institutional. And we've listened to a lot of facts, and maybe it's more a gatto than a cake, but we've heard it from everybody. It's a fact. And we will be very acutely conscious that we will filter what we view as elegant, attractive submissions from what's in the judgment and what's in the decision.
I'm grateful, my lord. My fourth point, I want to summarise overall what went wrong with the CMA's decision from our perspective. Above all, we say, even second time around, the decision contained no empirical analysis of what is a normal profit margin for a medicine like phenytoin, or indeed any medicine. Instead, the CMA adopted an economic theory which found that pharmaceutical companies should price at cost, including the cost of servicing capital, for example, bank loans. It also found that Flynn was only entitled to earn a return on a small component of its costs, its so-called capital costs. And in combination, this produces what your lordships may have seen, we submit, would be an absurdly low result. It means that the simple maths means that Flynn's reasonable rate of return for selling all 4 strengths of phenytoin is just £66,000 a year. That's just the mathematical expression of what the CMA found to be Pfizer's reasonable rate of return, to which we've added what the CMA found to be our reasonable rate of return. And we do submit that that is an absurdly low figure for taking on.
Is that a new fact?
I'm sorry?
Is that a new fact?
No, my lord. This was all canvassed extensively at the trial. It's in, for your note, I was going to give you this. It's in Dr. de Koninck's evidence.
But is it in the judgment?
The maths had never been disputed by the CMA. I'm just making a maths point, my lord. But we do submit that the responsibility of selling 4 separate drugs to the NHS as a marketing authorisation holder, which, as your lordship knows, comes with significant regulatory responsibilities. It's just miles away from the sort of figure that would make that a sensible...
I'm sorry, just to clear, the 66,000 is Flynn alone?
Flynn.
Just Flynn?
It was what Flynn would get at the end if you take the CMA's approach to Pfizer's price and then the CMA's approach to what Flynn should have earned. Mr. Pascoe is going to develop in much more detail, and no doubt much better than I could have done, the more technical points, but I just wanted to say that. And we do say in those circumstances it is unsurprising that the decision was set aside. And although the CMA protests that it considered comparators in detail, producing a long decision with many paragraphs reciting arguments is not the same as conducting a real-world investigation and analysis of the normal returns for a medicine such as phenytoin. That is what the tribunal in its 2018 judgment said should occur. That's original CAT judgment at paragraph 318 for the note C, core bundle, volume 2, tab 30 at page 518, electronic page 593. Now, regrettably, we submit the opportunity for real-world analysis was missed, even second time around, and the decision has rightly been quashed by the tribunal because it fell into that similar error. Fifth, and although I come to this point last, maybe I should have addressed it at the outset, the question of what happens next. In light of the court's indication of its provisional view, we are focusing our submissions on the CMA's appeal rather than on our appeal. Now, without jumping any guns, but I do need to address this for Flynn because it's so important. Yeah. If the CMA's application or appeal are dismissed, as we submit it should be, and the second part of the judgment is set aside for procedural unfairness.
You say enough is enough?
We say absolutely, my lord.
Well, I'm sure we're sure that's what you would say. If we get to that point, you know, we'll have to decide what we do. We may just come back to the parties and ask for submissions. I don't know. We may not get there, but I mean, I'm not suggesting or hinting back anything whatsoever. But we understand that point. I mean, it's obvious.
I understand. I'm grateful. But if I may, the key point which we need to stress from Flynn's perspective, given everything that's happened over the past 13 years, is that it is indeed high time for this saga to end. Flynn is a small domestic...
After 14 years, I mean, even those who are subject to regulatory investigation are entitled to a degree of speed and legal certainty. You know, these things can take a number of years, but the fact we're now 14 years in is not happy. From whoever's perspective, from the CMA's perspective, they have to apply the rules. They need to know what the rules is and have proper guidance from the CAT. So
absolutely.
It's an unhappy and unsatisfactory state of affairs from whomever's perspective you look at it.
I'm very grateful, my lord. And for Flynn, as a small company, it's been particularly burdensome. This appellate ping-pong that we've had, your lordship can imagine. I think in our principal written submissions, we said that it doesn't cast UK competition law in a favourable light, and I do submit, I'm afraid that's the case. But it has had a major effect and effectively paralysed Flynn's business because of its size. Now, of course, the CMA have seen things differently, and we're going to come back to that in the context of our response to the CMA's proposed appeal. But this has been tortuous for my clients, and I do need to say that.
Findings of fact to that effect. I mean, I know where do we find any evidence to underpin what you just said?
Well, Mr. Fakes gave evidence, I think, at the start of his witness statement. There's a description of Flynn as a company.
Is it in the judgment? Or?
It's probably in the CMA decision. I mean, the size of Flynn, it's a British company, those sorts of points. I'm certainly not giving evidence, my lord, about anything that's controversial.
I think it was more the paralysis that you say that has been caused. Size, well, I'm sure the size is dealt with somewhere in the remainder of the business, but it's the specific point you're urging.
I accept that's my word, my lord. And if that's problematic,
well, if there's some particular reference that you'd like us to look at to back up the submission you've just made, I think I'm sure you can be provided with it.
Yeah, I'm grateful.
I mean,
relevant also.
Liquid criticised.
At the moment, I don't think I've seen it.
Yeah. So I'm yes, I do recollect now. In as I mentioned, in David Fakes, who's one of the directors of Flynn, in his witness statement, he gave evidence at the second trial, and he wasn't challenged on any of this, but he describes the effect that it's had on Flynn's business.
Okay, so you can give us references.
Shall I give you? We can give you. Yeah, we'll have to give you the whole. I think we would, believe it or not, we were trying to be abstemious, Flynn, in what we put in the bundles. So the whole of his witness statement is not actually a long witness statement, but we did confine ourselves to extracts. We will get you the.
Just give us the references later.
We'll just give. Well, it's not in the bundle. This particular part of his witness statement is the point, but it is there. It was in evidence.
Well, if it is, send it to us. Make sure the CMA have it, and we'll see whether the CMA agree or disagree with it.
Yeah. Well, they didn't cross-examine on that bit of his witness statement, so I really. So I think I'll leave it there, just to say, if the court isn't with us and considers that some form of remittal must occur, then we do agree with Mr. Holmes that the position is complex. And I understood Mr. Holmes to recognise that even if the CMA wins the appeal, that wouldn't be enough to restore the CMA's decision and your lordship's heard.
It's an exercise of discretion then by us as to what
Indeed.
we do.
So we agree that there would be, as your lordships very helpfully indicated, be a need to address that in due course.
Well, it would be a bit odd if we didn't ask the parties, given that one of our concerns about the CAT was that it didn't ask anybody what their view was once you'd won and you'd lost. I think everybody was entitled to have a say about next steps. It's normal procedure. Anyway.
Turn to the structure of our submissions, my lord. So I'm going to address next ground 2, little Roman 2 of the CMA's proposed appeal, which concerns the TAVR tablet price. It's the mirror image of ground 1 of Flynn's appeal. So in responding to the CMA, you will hear some of what I would have said on that. Next, I'll say something.
Sorry, could you give me the ground of appeal in words rather than numbers?
Yes, this is the TAVR tablet, TAVR drug tariff tablet. Again,
But from your point of view, is this evidence which goes to plus or to
it goes to
or fairness?
fairness. Then I'll say something a bit shorter.
And just to put it to, in other words, justifying a price above cost plus.
Yes. I'm grateful. Then I want to say something, well, it's all going to be short, but even shorter, about the CMA's ground 2, little 3, and that's on comparators, and that links into points arising from our respondents' notice. So I'll say something very short on that. Then Mr. Pascoe will address your lordships on the CMA's proposed ground 1, little Roman 2.
Is that whack?
That raises economic points relating to the CMA's benchmark for excessiveness. Yes, my lord, it's really the heart of what the CMA say about excessiveness. Mr. Flynn, Mr. Pascoe will also address briefly.
That's Ros or Roke?
Well, obviously, Rocky was applied to us.
Yes, exactly. You said it should have been ROS.
It should have been, I'm sorry.
Ros.
Well, that was our position. That was one of our grounds of appeal. We didn't succeed on that in terms, but Mr. Pascoe is going to navigate through that part of the judgment, and he will deal briefly with the other bits of the CMA's ground 1, so covering excessiveness in response to Mr. Bailey. Mr. Pascoe will also, at the appropriate point, necessarily very shortly address 2 our key points on penalties, which shouldn't be totally forgotten, as I mentioned yesterday. No. But we do recognise that purely for timing reasons, and this says nothing about how important the points are, we will need to leave much of the detail of the penalties arguments to the written submissions. Of course,
Yes.
we maintain all of our points in the written pleadings, including our own appeal points insofar as they arise, and we are very grateful to the court for its indication that it's content to proceed on the basis that simply because we don't deal with something orally, it's in some way of secondary or lesser significance. I should say, because there was quite a lot of ding-dong in writing prior to, in the written pleadings previously, also where we don't deal with every point in writing in a document, that was for reasons of space and economy only, because the court had very sensibly imposed page limits on the parties. So, my lords, the CMA's application for
So
permission...
when you say pleadings, are you talking about skeleton
I'm
argument?
sorry, I'm talking about what have in this case been called principal written submissions,
Yeah, okay.
response submissions.
Yeah, no, it was only because then you said
Yes,
the
I'm
court
sorry.
had imposed page limits, so I thought the court had actually extended them, as opposed to saying stick to the normal 25 pages.
Well, actually, we had a bespoke regime from my Lord Justice Green.
It's
Which-
my fault.
I was going to say,
Yes.
perhaps the rest of us could have done with
Different.
25 pages only and leave Lord Justice Green with the rest.
So, what I want to stress at the outset of dealing with the CMA's appeal is that it is enormously ambitious. It seeks to overturn the whole of the first part of the judgment. And of course, the CMA wants to have its decision reinstated. It's also highly ambitious in another respect, because the CMA rightly accepts that some of its grounds do require it to show irrationality. Irrationality of findings based on the expert evidence. For reasons that Pfizer has already addressed, and we will just add a few points, we submit that the CMA hasn't come close to meeting that threshold. Now, do we say we won every last point in part one of the judgment? No. Do we say we would have expressed ourselves identically to the tribunal? No. As we've acknowledged in a few places in our principal written submissions, candidly, and as Mr. Pascoe is going to come on to acknowledge, the judgment is in some places discursive. It jumps between topics and ideas, but we do submit that that is very far from justifying a wholesale overturning of detailed conclusions reached in, as has been noted, a reserved judgment arrived at after a 6-week trial. So, turning to the CMA's ground 2, Little Roman 2, which my Lord Justice Zacaroli concerns the drug tariff price for tablets. And I start with this because it is a point that's particularly important for Flynn, not least because it reflects the reality of how Flynn actually set its price for phenytoin and how it discussed with the department setting the price of phenytoin. Pfizer has already addressed you on the more generally on the key flaws in the CMA's ground 2, and of course we endorse and adopt all of that. But I just want to add, rather than in any way duplicate, and focus in on CMA's ground 2.2. As your lordships know, this ground of appeal targets in particular paragraph 255 of the judgment and the tribunal's finding that the £30 drug tariff for tablets was, and I quote, it may be helpful to have it open, that's Core Bundle Volume 3, tab 32, page 864 hard copy, and the electronic page is 939. So that your lordships are familiar with this now, they found it was a relevant factor that could and should have been considered by the CMA when determining the unfair limb. Before I come to deal with the CMA's arguments on this, as developed by Mr. Holmes, I just want to very shortly outline the issue and what part one of the judgment found. Now, I'm of course very conscious the court's already heard submissions on this, and my Lord Justice Green has made clear he's familiar with the relevant section of the decision dealing with the TAVR drug tariff price. But I go back to this because it's one of the peculiarities of this case, of this particular pharmaceutical excessive pricing case. And my Lord Justice Green made, if I may say so, the wise observation on Tuesday to Mr. Holmes that the court needs to be very careful to confine itself to the facts of this case. As your lordships know, the drug tariff is simply a list of the amount paid by the NHS to pharmacies for items including generic medicines. It's updated monthly and it's now published electronically. It's simply a list in pounds and pence of what pharmacists are reimbursed by the Department of Health for a particular drug when they dispense it. So it's sometimes also referred to as the reimbursement price. For Flynn's phenytoin sodium capsules, the drug tariff was determined by reference to the list prices set by Flynn. But the important thing is that the drug tariff are the prices that are ultimately paid by the NHS. Just for your note, that's a statement from the CMA's decision at 2.293, which is Core Bundle, Volume 4, Tab 33, page 1054, or electronic page 1129. No need to go to it. But it's not controversial, what I'm saying. This issue, as your lordships know, arises out of the amount that the department had agreed to pay for the phenytoin tablet. So it was a clinically identical product sold by another company, TAVR. Flynn's short point is that it cannot be right to subject the seller to a quasi-criminal sanction for charging a price which is lower than the price its customer has agreed to pay a competitor for the same product. Now, the drug tariff...
Say a competitor?
Well, TAVR is another pharmaceutical company.
Yeah.
I'm sorry, my lord, I'm not at the moment, and I'm going to come on to this.
That begs the question of the quality of the comparable.
I'm going to come on to that, my lord. I'm trying to just lay the groundwork here as quickly as I can.
It's right to subject the seller to a quasi-criminal sanction with charging a price which is lower than
the price that its customer has agreed to pay. Maybe we should just say another company. I did say competitor, but another company for the same product. The TAVR drug tariff, as your lordships know, for 100 milligrams was £30. TAVR only sold 100 milligrams, so that's the dosage that this relates to. The drug tariff price for the tablet did reduce towards the end of the relevant period, just for the sake of accuracy, so from April 2016. But the important point is that it was at all times during the relevant period higher than the price of capsules. Again, that's common ground. And of course, your lordships, I know, have the point that 100 milligram capsules were sold in packs of 84, not 28. So quite often you need to be dividing by 3 to get an equivalent price. Now, I'm very conscious that Mr. Brearley in particular has already addressed the court in some detail on this. So I'm going to add just 5 points, if I may.
So just to be clear, am I right in thinking that the TEVA price or the DHSC price of £30 per TEVA has to be trebled to compare it with the 100 milligram capsules.
Yes, the pack sizes are just different.
Yeah.
I'm grateful. So my 5 points, and then after I've done that, I will address the CMA's. They've basically got 3 main arguments that they raise on this, but 5 points first. First, Mr. Brealey referred the court to the actual email communications between the department official who was conducting the negotiations and Teva. I'm not going to go to the actual document, but if your lordships are curious, they are in the core supplementary bundle, in particular at tab 29. There are a few, and they're very short. We do submit that they paint a very different picture from the one that anyone was aware of when this matter was last before this court, or could have been aware of. As has been explained, the documents were only disclosed after this court's last judgment, and they do put what was previously held about Teva's market power and the circumstances of the agreement in rather a different light. Second, the documents show that the £30 agreement was obtained by the department threatening to cap the price of the medicine, not by the sheer force of Teva's market power. Third, my Lord Justice Green expressed surprise that there wasn't more analysis in the tribunal's judgment behind its rejection of the CMA's case, that the agreement was the result of Teva's market power and nothing else. Now, the tribunal did analyse the evidence before it as to the circumstances of the meeting. What was not before it and was any evidence of why the particular figure of £30 was the price chosen by the department. Now here, I'm going back to some of what my Lord Justice Green explored with Mr. O'Donoghue this morning, very briefly, but for reasons that have never been explained, the CMA chose not to call any evidence from the department. The department could have given evidence about this. So to the extent that there is any gap, we say it can't possibly be laid at our door. Fourth, the established fact is that the department agreed the tablet reimbursement price of £30 and said it was of value to NHS patients. And with the greatest respect to my Lord Justice Green, we don't see how an agreed price by the NHS with a main competitor can be irrelevant just because it's an agreed price.
No, I hope I wasn't suggesting that. I was simply trying to work out what the cat had said or did not say.
I'm grateful. I had in mind exchanges on day one.
Yeah, just to be clear, it didn't actually say that the £30 was of value to the NHS patients. They were able to reach a conclusion which is of value to NHS patients.
Yes.
It's a very...
Well, it was a price negotiation. There was horse trading, as one can see from if one reads up the chain.
It goes back to this point of what do you actually mean when you're talking about price, benefit, value, to whom, is it economic?
My lord, that makes a fair point.
What we're really saying is we've done a deal that will be of value to NHS patients, but I'm not sure I can quite read into that £30 is, as it were, a number or a price which is all value.
Well,
I don't think I can make that illusion at the moment.
My lord, we had the trial about that. The tribunals reached the conclusions that it reached.
Anyway, I don't suspect that this case is going to turn on that one email, but there we go.
But we do also submit that the £30 can't be dismissed because of concerns about whether there was workable competition in the case of Teva's tablets. And there was also discussion about this yesterday with Mr. Brealey. The agreement is just a different species of evidence that goes to fairness. So one type of evidence that could go to that issue is the outcome of a workably competitive market. Another is the price that a monopsony buyer, the Department of Health, negotiates and agrees to pay on the basis that it represents value, whatever that means, to the NHS. So that's my fourth point. Fifth, of course, the person agreeing the price here was not any old customer. It was the department with its immense knowledge of pharmaceutical pricing and under threat that if it didn't get the price it liked, it could exercise its statutory powers. Now, to be clear, I'm not making a technical argument that a competition authority is in some way bound by the price that has been agreed by a buyer, or that there's some form of issue estoppel or anything like that. The question in our submission that the court must ask is whether Flynn's prices were unfair, no more and no less.
The point was made yesterday, which I think we buy into, which is that a test for fairness is whether a reasonable buyer would agree to pay something. And here you have a knowledgeable, reasonable buyer. So that is at least admissible and relevant evidence for that reason, if for no other reason.
My lord, yes. So we do strongly submit that one can't say that price, negotiated and agreed by the main buyer in the market, with all its expertise for a clinically identical product, is irrelevant to the question of whether Flynn's price was fair. So turning, if I may, then to deal with the CMA's three main arguments, as we understand.
But can you, at some point, just attach everything you've said into the CAT's actual reasoning?
Yes.
Because for us, you made some very attractive points by reference to a wide variety of considerations. They're not always the ones that CAT used in its own judgment. And some of them perhaps more cogent than others.
My lord,
everyone says to us, stick to what the CAT said, treat this as a narrow appeal on points of law, don't get distracted by the evidence, etc., etc.
Yep. I'm about to come to the judgment, my lord, if I may. I wasn't going to go back to it in detail because I'm very conscious of the judgment I shouldn't duplicate.
No, but we need your position on some of these conclusions by the CAT, some of which I say are perhaps more convincing than others.
My lord, so I'm going to first, if I may, deal with the CMA's first argument, which is they say, well, the drug tariff price for tablets wasn't a competitive price and so shouldn't be of any relevance. And for your note, that's, for example, their principal written submissions at paragraphs 72 to 74. No need to turn it up.
When you say it wasn't a competitive price, do you mean it wasn't a price that was reached in the circumstances of a workable market?
Yeah, they say Teva had market power, so forget all of this. Now, the tribunal, as your lordship saw yesterday, did address that argument squarely in our submission at paragraph 254, subparagraph 2. That's Core Bundle, Volume 3, tab 32 at page 861, or electronic page 936, I hope.
Yes, it is.
Grateful. So I was going to go back to this really just for one limited point, because I heard the exchanges yesterday, particularly with Mr. Brealey, and the point I wanted to draw attention to, which I don't think was specifically highlighted yesterday, the court's seen the factual findings at 3 and 4 and over the page at 255, and there's been a certain amount of debate about what they say, and we do very much endorse Mr. Brealey's submissions on this, that there are clear factual findings. But there is one other that I just wanted to highlight. Your lordships have probably noticed it for yourselves already, but at the start of paragraph 2542, which is of course headed, "The drug tariff was not a price set in conditions of effective competition," there's then a quote from para 6.192.2 of the decision that Mr. Brealey took you to yesterday. For your note, that's at CB volume 4, tab 33, page 1245, or electronic bundle 1320. But I just wanted to highlight that after that quotation, there is another clear finding immediately after the quotation, where the tribunal says we do not accept the CMA's reasoning in this regard.
I'm sorry, can I just take you back to what they say at the beginning of 2? What do we make of the statement that the CMA appears to have concluded that the drug tariff was, must be an abuse of a dominant position, the outcome of a competition law infringement?
Well, I think
the first time round, the CAT told them to go away and do a much more detailed analysis, in particular of market power, which they did, rightly or wrongly. Does that necessarily involve the conclusion that Teva was abusing a dominant position?
Well, this is an introduction to the quotation at the top of the next page.
I don't think it follows from the quotation that there was a finding of infringement. They're just facts. Unless there's a dispute about monopoly supplier. But I don't think that was... it may be a forensic point, but it just seems an odd start.
I don't think we need to go that far. We haven't gone that far. But I'm trying to meet and stress that for all its complexities in this paragraph, the tribunal says expressly and squarely that it didn't accept the CMA's reasoning, its decision which it had quoted. Now, how does the CMA attempt to impugn these findings?
It may just be the same question my lord's just asked in a different way, but is it right? That is the quote. Did the CMA make that finding, and why did it matter?
I'm sorry, did the CMA make the infringement finding?
Yeah, and why does it? Why does it matter? Does it matter?
I don't think they did, as a matter of fact. No. But
why does it matter anyway? If there's a simple question about the fairness or otherwise of the pricing.
Well, as I submitted a few moments ago, we do submit that this is just a different species of evidence. We're not actually talking about whether there's workable competition or not here. It's evidence of a negotiated agreement and a price, and that does, in our submission, go to fairness.
But then, is there little to the nature of the drug tariff is mischaracterised? What in the quotation above is treated there as a mischaracterisation? Because again, I have difficulty in understanding the CAT's logic. We do not accept the CMA's reasoning in this regard. 1, the nature of the DT is mischaracterised, not a price at which seller sells, a ceiling informed by factors. I didn't think that was in dispute, really.
My lord, I wasn't going to take up time with this, and I'm not sure it doesn't provide a complete answer, but if one looks back at paragraph 123 of the judgment, where drug tariff is defined, the tribunal was at pains to stress that in its view, the drug tariff, it's not accurate to refer to the drug tariff as a price. This, for your note, that's on page 737
Yeah.
of the bundle. So my my explanation for what, I don't think I need to explain it, but I think that is what the tribunal point that was being made at that point. It's not a price as such. And if one looks, actually, the tribunal is quite careful never to refer to the drug tariff as a price. It refers to it as a rate, but not. Now, call me simplistic. I think if something's in pounds and pence and is paid by someone, it's a price. And both we and the CMA have used that word, but that is something that. I'm sorry?
So did Pfizer.
Yes, all of us. Yes, we all use it, but it is something that
we understand. Okay.
and it may be one of the. As I say, I wasn't going to go into any of this, partly for reasons of time. It may be one of the preoccupations that lies behind what the tribunal then says in part 2 of its judgment.
Yeah.
At paragraph 315, which I am going to deal with.
I don't want to take you off call, but can I just tell you what my concern is about this section? So,
yes.
Little I didn't think that was in dispute, and I'm not certain when they criticise the CMA for a mischaracterisation, I didn't think that was factually accurate. Little 2 is the point about the per se presumption, which they here say is a predisposition, not a per se, but they say that their criticism really flows from their understanding of the CMA's position. It's not really about market power or anything to do with market power. And then we get into the question of negotiation in little 3 and 4, in which the CAT seems to, well, and then with 3 below, they seem to be equivocal. They're not certain that that's relevant, and insofar as it's relevant, they accept pushback may be relevant. But there's no analysis of market power.
Well, my lord, I agree with what Mr. Brearley said about this yesterday, that insofar as the tribunal pulls back from making, it says it doesn't need to make certain findings of fact about what exactly happened. I think I read that as we're not going to get into the details of the horse trading that went on in the negotiation.
Yeah, but is there anything there which you say is an answer to the question, which is posed by the CMA, the drug tariff was not a price setting conditions of effective competition?
Well, they've found that they don't accept the CMA's reasoning, and they've given reasons which clearly your lordship doesn't find
I'm
most
just
compelling.
trying to find what it is that addresses that particular issue in these 4 grounds.
The price control was negatived any market
Mm. Mm.
I'm sorry, I've asked you an impossible question. I mean, we can all read it.
Yes.
We can try and get
My
our
lord.
heads round whether it's an answer to that question or not.
Yes, well,
Seems to me that it's building on the characterisation of the CMA saying there's been an infringement. Doesn't it build on that in subparagraph 3, what we were discussing yesterday? This seems to be the only subparagraph which directly responds to the CMA's finding that it wasn't a price setting workable competition. But the building on the idea that it was infringement, the CAT then says we're not satisfied. It probably said that DHSC was induced to agree a drug tariff that was inconsistent with its public law responsibilities. But that's not what the CMA was saying.
that's a sort of intellectual interpretation of what they would have had to be doing if they'd been wrongly influenced, and agreeing to a price that wasn't a fair one. It's my understanding.
Wrongful. It's just saying as a matter of fact it was reached in a condition of not workable competition.
I'm sorry, I'm getting a lot of noises off. Very helpful noises off, I'm sure, but I can't.
So it doesn't meet the point that I'm suggesting that the CMA has made. It makes the leap that the CMA must be saying that the DHSC was therefore acting inconsistent with its public responsibilities. But That's not what the CMA said. It doesn't follow.
No, the CMA, I fully accept the CMA didn't put it in that way. So the helpful noise is off.
It was an implicit finding
Ask-
of infringement.
Asking me to remind the court that in the decision at paragraph 6.202, which is at page 1248 of the hard copy, I'm afraid I haven't got the electronic bundle reference to hand, it implicitly, it says prices which themselves have been inflated by the exercise of market power will not be meaningful comparators.
So which paragraph are you reading?
I'm sorry, it's 6.202, 202.
And then it cites the authority.
6.202.
And it cites
Electronic 1323, my lord.
and it
Very
cites-
grateful.
It cites,
Sorry.
it says that it's
I think Mr. Brealey is saying that it cites various cases in a footnote.
But
And
let's
therefore
say
you
it's
could
an abuse.
assume.
Albion
use-
water and...
Yeah. I mean, it's difficult to conclude that they're finding an infringement against Tether there.
Well, Mr. Brealey thinks it's an implicit finding.
cat as it is.
I hadn't thought we needed to go that far, but I do take Lordship's point that the...
Well, I mean, you know, sitting here, we've just got to look at what the cat said. And we understand you've got respondent notice points, and you know we've been referred by Mr. O'Donoghue to other paragraphs which address pricing. We'll have to look at those. But in terms of just an exercise in logic and reasoning,
Well, clearly
Right.
your Lordships don't think much of paragraph 254, and but
we just need your help in it,
It's-
really.
yeah,
I'm sorry, this is a series of unfair questions because we can all read it and decide whether it actually addresses what it purports to address.
yes,
Anyway.
yes. I mean, they set out the paragraphs which say that Taylor had market power, and then they deal with it in ways that I understand your Lordships don't find wholly satisfactory, but they do reach the clear conclusion that the drug tariff is a relevant factor that could and should have been considered by the CMA.
Yeah.
So if I may then turn on to the CMA's second argument, they say the drug tariff can tell us nothing because it sits at a different point in the supply chain. The court recalls that part of Mr. Holmes' submissions. Just for your note, it's in the CMA's principal written submissions at paragraph 71, and also in their response submissions at 26 to 27. Now, that may sound superficially attractive, and it's a point the CMA are very keen on, but we submit it is a bad point. And that's because of some of what I said at the outset, that the price that the department paid for the capsules was at all times less than it paid for tablets. And the fact that Flynn sold its capsules to the department from a lower level in the supply chain through wholesalers and distributors is, we say, irrelevant. The important question is, what did the department pay? Because that's always been the focus of the complaint. So this, my lord, this is not a margin squeeze case where the authorities were worried about how much margin was left in the system for wholesalers and pharmacies to make a profit. To put it more bluntly or crudely, the CMA argues in its reply submissions, this is paragraph 27, that capsule ASPs were considerably higher than tablet ASPs. We heard similar from Mr. Holmes on Tuesday. And the CMA say, well, that's the end of it. Compare like with like. But the capsule drug tariff was, we know, considerably lower than the tablet drug tariff. Why was that? It was because wholesalers in the middle of the supply chain made less money on capsules than tablets. But we say that that's legally irrelevant to an excessive pricing claim against Flynn. This is not a complaint by wholesalers that they were squeezed. It was a decision of the CMA prompted by a complaint by the Department of Health that they paid too high a price for capsules. And the price that the department paid was the drug tariff price. Now, there is another point here, which is that the only published figure for tablets when Flynn was setting its price was the drug tariff. And we submit it would be wrong to find that an undertaking was acting abusively when pricing at a discount to the published rate. Of course, the tablet ASPs were confidential, and this court made or adverted to this point in liothyronine at paragraph 202 about the preferable nature of published
Oh, yes. I remember.
published information. So we do submit, we can turn it up if
No, I remember.
what we'd like. The public nature of the drug tariff for tablets is another reason why it's, in our submission, a particularly important benchmark here. Certainly, as the only public price signal, we say it can't be dismissed as entirely irrelevant. And I think I've got time. I think it would be worth just looking very briefly, as your lordships may not have had time to look at it, at the evidence of Mr. Williams on this. He was Flynn's industry expert. Indeed, Flynn was the only party to have such a witness with that particular expertise and experience. And Mr. Williams' sixth witness statement is that it's in the core supplementary bundle, which is supposed to give your lordships the really important documents. Have you got that?
Core bundle volume.
So core supplementary bundle. If your lordship
Yeah.
seen that, yeah. Tab 14, page 122, and this is where happily the electronic page numbering is the same.
Sorry, because of the noise, 120.
Well, it starts at 121.
Yeah. You wanted to go to which?
And then I was just going to ask your lordships, if you didn't mind, very quickly to read from paragraph 17, which is on page 125. It's really the second half of 17 in particular. In my submission, it's just quite helpful as an explanation of what the drug tariff is doing from the perspective of the pharmaceutical company. And the final sentence of that paragraph, Mr. Williams says he's aware from discussions I have with pharmaceutical companies on pricing that the DPT prices of comparable drugs are routinely used by pharmaceutical companies as benchmarks when launching new generic and branded generic products. And then I think we can skip over to the following page and paragraph 20. Where your lordships will see that he's explaining a company will have regard to certain factors. It will know the DT price. If this is published monthly, may even know the list price if they choose to list them. However, the actual ASPs of its competitors will generally be unknown to the supplier. These are not available in the public domain and normally below list and DT prices. And then paragraph 21, you can see, maybe if the court doesn't mind just glancing through that, Mr. Williams' view that he would be surprised if they wouldn't have considered that price. And it was set at around a 25% discount from the DT price for tablets. Now, to be fair, I should say that Mr. Williams was cross-examined by Ms. MacLeod on these paragraphs, but although she put to him that the price increase generated outrage, and so wasn't normal in that sense, there was no suggestion that pricing isn't normally done by reference to the DTs or that ASPs could be considered or anything like that.
This is not in the judgment. I'm not saying
it's right that yeah.
I mean, it may be not an issue in dispute, but Mr. Actor, take as a premise that you're right, that generic companies look to the DT as some sort of a benchmark or a guide, or as information. Can I ask you two questions? A, what does that lead to? And two, if the DT is X hypothesise a bad price because it reflects market power, should one bad turn deserve another?
So on the first question, it leads to, it cannot possibly be an irrelevant factor. It is, we say it's, in this case,
it's a real world relevant factor.
And here it was a particularly unusual way in which the DT price had been arrived at, as courts see. So we do say it's highly pertinent. I'm being asked to remind your lordships, you may recall from liothyronine that there the CAT, and just for your note, the reference is paragraph 240 of the tribunal's judgment in liothyronine, which is in the authorities tab 52, page 794.
And the point?
I'm sorry?
The point?
Well, the point there is just that the CMA market participants will often take the drug tariff as a reference point.
Yeah. So
it was
the
the CMA's
follow-on question.
Sorry. Yeah. Yeah. And of course, in our judgment, at paragraph 254 that we were just wrestling with, at 254(2) little 4, little Roman 4, the tribunal does reach the conclusion that the appellants were entitled to rely upon the drug tariff.
Yes.
For pricing information.
But it may or may not be particularly controversial that it's a factor which is capable of being informative. So perhaps the more important question is the follow-up one, which is really the one the CAT identified first time round. How informative on the facts, and whether or not it's reflected by market power. And if it is, then put it over simply, does one bad turn deserve another? Is that bad signalling? And maybe it's signalling which competition law after the event says is bad, but at the time doesn't appear to be bad, which may be a relevant factor, I don't know.
Well, we submit here the drug tariff was set in the very unusual circumstances that we've seen, and so that's my first point. My second point is the tribunal has clearly rejected the CMA's position on market power, on Tavor's market power, being the explanation for why the £30 was arrived at. And this court, with great respect, in our submission, can't.
All right, let's assume again, test the argument, push a bit. assuming not with you on that because we're not satisfied with the CAT's reasons, it maybe is a fairly stark point. What is the relevance of the fact that at the time, industry participants thought that the price was informative and used it, even if some years later after the event, a competition authority comes in and says, actually, we now know that's a bad point?
Well, we submit that, first of all, it is as I tried, obviously failed to say earlier, sufficiently clearly earlier, it is a different species of evidence going to fairness, this agreement. So we'd say it definitely doesn't fall over just because there's a later finding, if there were a later finding, which of course there hasn't been here, that in fact there was no effective competition or not sufficiently effective competition in relation to the Tabor tablet. So we do maintain that. And it is, with respect, important, as your Lordship's question points out, what parties in the market at the time knew and what signals they could take from this £30 drug tariff in the real world.
To be relevant to penalties, I suppose.
Well, certainly to that, but we say it goes much further than that, my Lord.
Yep. Thank you.
I said I had 3 points, so just the third main point the CMA advances, they say, well, if you're correct about this, about the relevance of DT tablet prices, that would have been a reason for finding that Flynn's prices were not abusive in the first round of appeals. And say that at various points, principal written submissions, para 126, response para 29. So they say, well, you just can't be right if it was such an easy answer. But we submit that's putting things the wrong way around. Just two quick points on that, if I may. At the first hearing, the original tribunal found that the CMA simply hadn't properly investigated whether the DT price of tablets was a useful comparator, and, as your Lordships know, remitted on that basis. Second, and this is coming back to the email about the Tabor agreement, of course we had the new fresh disclosure from the department between the first and second set of appeals, and we can now see what the department said about the £30 price, and that led, in our submission, the tribunal to conclude in the terms it did. So we do submit there was highly material new evidence disclosed before the second tribunal hearing. Just before I finish this section of my submissions, and I'm very conscious of time, I should respond to one point that Mr. Holmes made on economic value. He claimed that Flynn was in a different position on this from Pfizer because it wasn't a manufacturer and so couldn't pray and aid any of the medical evidence showing the economic value of phenytoin. And we submit that isn't the right analysis. What matters is the price charged for the product. We were supplying phenytoin to the market at a price, and the medical benefits and economic value of the product are just as relevant to the legitimacy of Flynn's price as they are to anyone else. And I really wasn't proposing to say any more on that. For the same reasons, we share Pfizer's great concerns about the fictional patient test. And that obviously arises from part 2 of the judgment, but just to be clear, had it been raised with the parties in the normal way, we would, of course, have made submissions on it. I'm saying that because it's been suggested, oh, well, it doesn't affect Flynn, and we don't accept any of that, my Lord, just to be clear.
Well, you'd have made submissions on that and a host of other things.
Absolutely, my Lord.
Which the CAT would ex hypothesis have given you at least some indication of?
My Lord, I come now more shortly to make some Flynn-specific points in response to the CMA's ground 2(3), which concerns comparators. And I want to highlight 2 points before coming to our respondents' notice. The first point, and the CMA has variously described it as its overarching error and its central complaint. That's in their principal written submissions, para 76, and their response at para 32. And it's the claim that by preferring the expression real-world competition over sufficiently effective competition, the tribunal applied the wrong legal test. And this was the point that I told Mr. O'Donoghue I'd come back to. Now, in his oral submissions, it's fair to acknowledge that Mr. Holmes, I think, accepted that this point doesn't really take one very far. That's day 1 of the transcript at page 155. But this point is at the forefront of the CMA's written case, so I do need to deal with it. We submit it's a technical point which cannot possibly amount to an error of law. And that's because, and I know my Lord Justice Green and probably the whole court has this point, but the tribunal defined real-world competition as, and I quote, synonymous with the phrase normal and sufficiently effective competition.
As used in United Brands.
Coined in United Brands, yes, my Lord. That's, for your note, that's paragraph 140 of the judgment. It may be worth just having the judgment open again, if you don't mind. So we're back to Core Bundle 3, tab 32. And we do say, so they make this point at 140, and then it's plain. If court were to glance down to 141, we say it's plain the tribunal was seeking to draw a distinction from the notion of perfect competition, which it refers to in the first sentence. So the phrase that the CMA have alighted on, which comes later in the judgment at paragraph 267 at page 869 of the bundle, or electronic page 944, saying that the tribunal was concerned at the introduction by the CMA of a new test of sufficiently effective competition. And perhaps the emphasis in the tribunal's mind was on the word sufficiently, we don't know. But we do submit that it has to be understood in that context. And the point the tribunal was making, and this is clear from the next sentence at paragraph 267, was that what is required is real-world competition and not perfect competition. My Lord, this is page 869, or internal page 231 of the judgment. So what's required is real-world competition, not perfect competition, and that comparators can only lawfully be dismissed in a binary way if the market was so impaired as to be valueless. So the tribunal was making the point that the CMA needed to say if that was its view. Now, perhaps, possibly recognising the force of that submission, the CMA in its response submissions acknowledged we might be correct about the definition of real-world competition. That's response paragraph 33b. And that was, I think, the effect of its position before this court. Instead, it now erects another objection, that the tribunal was wrong to say a finding of impaired competition is a serious one, not to be undertaken lightly. That's paragraph 260 of the judgment on page, turning back on page 866, electronic page 941. We simply say that's an observation, not a legal test. I would refer in particular to the reference to a chimera of impaired competition
Yeah,
in the
it's an odd
previous
phrase, that.
sentence. It's an odd phrase, but this is not attempting to set up some new legal test in our submission. And we've explained, and I'm not going to take up time with it, we've explained at paragraph 19 of our reply why the tribunal's finding discloses no error of law. Rather, we submit, following a full merits appeal, the tribunal rejected the CMA's findings that the prices of Flynn and Pfizer's comparators were set in conditions of insufficiently effective competition.
Whilst we're on those paragraphs, can I
Yes.
just use you as a stalking horse for... in 259, competition authorities slow to dismiss comparables out of hand, but then they say they're going to be difficult to find. X hypothesize when the index market is dominant. By definition, there will be limited substitutes. Is that correct?
Well,
Not certain it's
depends.
correct.
It depends how strict one is about what can be a comparable.
But if you've got a dominant index market, then could we, as I think the Peterel shows, there may be lots of comparable markets which are very close where there is no dominance. So the CAT seems to think it's very, very difficult. Substitutes will be limited, and by definition, they're not going to be comparable, which is...
Well, they're not going to be exactly the
It
same.
may not be exact, but I mean, the whole question of a comparable, you've got to look at the product, its characteristics, how they equate to price, market. It's a factual question. There may or there may not be.
My lord, yes. I understand. I didn't have the pleasure of being at the first trial, but I understand there were exchanges there with the chair, Mr. Freeman, there, where he referred to
Yes.
comparables being defined out of existence,
Yes,
and one can see that
yes, that
can
could
be
happen.
a problem.
Can also, in the N260, which you've referred to, the second sentence is important. What is, if you like, the burden on the authority? They can't be expected to conduct full investigations of other markets as well as what they call the focal product market, the index market. I mean, do you accept that? I mean, there's got to be a degree of pragmatism on both sides as to the level of detail one goes into in the comparable.
My lord, yes, we're not suggesting that there needs to be a market investigation, but we do suggest there needed to be sufficient investigation
Of course,
to
yes.
obtain real-world evidence
And
relevant
then,
to our client's product.
so I think you probably accept it affects weight, but you've still got to do a proper examination. And then you get this statement, the authority cannot properly use the chimera of impaired competition to preclude considerations. Well, impaired competition is the very thing they say you have to look at. You've got to look to see whether it's impaired and then form a value judgment as to its probative weight as a comparable, taking into account market power. So here they seem to think the market power is a chimera.
Well, I'd understood that, rightly or wrongly, to be a version of the important observations that were made by this court last time round, that you need to look at weight is not a binary question, and that if we read, instead of the rather elegant word chimera, if that's just talking about the shadow cast by impaired competition to preclude consideration of comparables altogether.
And
So
maybe what they're
shouldn't
saying
be
is you can't say that because there's some impaired competition that precludes the value. That would be a chimera. You've got to actually look at it's a more granular analysis than just assuming it's a chimera.
Yeah, it's
There
weight.
is some, therefore it isn't as well.
It's weight, not a binary
Okay,
yes or no.
that may be a fairer way of looking at that sentence. Yes.
So, my lord, that's what we say about the CMA's overarching point. It was a bad semantic point. It's morphed into a different but equally bad point, and we submit it doesn't disclose an error of law. The second reason why the CMA's ground 2, 3 on comparators must fail is that the CMA is wrong to argue that simply because it included consideration of arguments in its decision, it didn't unlawfully disregard them. That's a point that they made in particular at paragraph 81 of their principal written submissions. Mr. Holmes developed. But the point the tribunal was making in our submission was that the CMA needed to consider comparables carefully and weigh them in the balance rather than simply concluding that the market was in some way impaired and then simply dismissing them. And my lord, we've already discussed at least our reading of paragraph 260 of the judgment, which we submit makes that point. So the simple point we make here is that having a number of paragraphs in the decision, even a good number of paragraphs in which the arguments of the parties on different comparables are set out but then dismissed out of hand in various ways, isn't the same as considering them in a lawful manner.
I just struggle with the dismissed out of hand. I mean, what happened here was they considered them, but in the end decided they were not meaningful comparators. So they considered them and gave them no weight. That's not unlawful, is it? It's a question of the weight they gave to it.
Well, on some of them we would say it was that they reached certain conclusions, which then meant that they dismissed them on a binary basis, i.e. giving them no weight. And this court has said very clearly in its 2020 judgment that that isn't the right approach.
We upheld the CAT's analysis. On these issues, the point that came to us was the CAT entitled to say that the decision was flawed because the analysis of medical evidence and tablets was insufficient? And we said, well, that's really a matter for the CAT within its judgment, and it was entitled to come to those conclusions. The CAT's analysis wasn't, you must find there's some value. It is, before you do that, you've got to do a better, more detailed investigation than you did before.
Well, I'm going to be repeating myself, but there is in our submission the important finding that it can't be dismissed on a binary basis, it must be weighted.
Yes.
Yes. Yeah. Yeah. And we do submit that every comparator was dismissed on a binary basis here. No weight was, because no weight was given to them. And we do ask the court to bear in mind that, of course, the appeal was a full merits appeal. The tribunal is perfectly entitled to find that an authority has wrongly dismissed comparators. The fact that the authorities considered them in the sense of turning their mind to them isn't an answer. This isn't a judicial review. Very briefly, on the Flynn specific comparators, which I should just address, to be clear what we're talking about, this is the exercise of looking at other products in the Flynn portfolio at the relevant time and the evidence of the return on those products.
So this is Ros, not Rogue.
In that respect, but we also adduced evidence of the rates of return of other pharmaceutical companies selling similar products on both the Ross and Rocky basis. For your note, and in case it is helpful, there is a list of the categories of comparators put before the tribunal at judgment paragraph 106, little 3, Roman 2. My Lord Justice Green has that. I wasn't going to go to it, but it's just quite a helpful list. Now, the CMA says, well, we dealt in significant detail with Flynn's arguments, and they complain about the tribunal not addressing Flynn's comparators. That's paragraph 82B of their principal written submissions before this court. We see, up to a point, we see eye to eye with the CMA on this. The tribunal didn't address the detail of our Flynn comparator submissions. They didn't address those detailed points because the tribunal considered it didn't need to, given the other conclusions it had reached about the flaws in and illegality of the CMA decision. If the court would find it helpful to have some judgment paragraph references on that, I can give you just a couple. There are others I could pick out, but just for speed, I'd highlight judgment paragraphs 183 to 184. That's at Core Bundle, tab 32, page 798, or electronic page 873. That explains why our comparators should have been taken into account but were not. It says they were potentially highly material evidence. And it's quite helpful to read that with paragraph 131, little 2, which explains that Flynn's comparators were relevant to the tribunal's preferred Rocky analysis as much as a ROS one. And then the only other one I'd mention, for timing reasons, is judgment paragraph 176, little 2. That's a Core Bundle, page 788, or electronic page 863, which says that even though the tribunal preferred a Rocky over ROS methodology, Flynn's comparators should not have been dismissed as irrelevant. And it says to require the production of comparables that closely compare to a product that's dominant because of its unique characteristics is unfair. And this is similar to what we were just looking at. The tribunal says the better approach is to accept comparables are likely to be somewhat incomparable, but not to reject them out of hand for this reason. The extent to which comparables are truly comparable should go to weight.
I'd welcome your views on that because it's slightly oddly phrased, but they are accepting that it's rare that you're going to get exact comparables because they are, as they put it, almost somewhat incomparable. Now, when you actually come to weigh them, it seems to be implicit that you can't attach quantifiable values to them. You're looking at something which involves an exercise in valuation or evaluation.
I accept that there's some.
For example, in
judgment.
AEDs, they say the evidence is at best impressionistic. What does an authority do with that? If they assume there may be some AEDs impressionistic value, how do you turn that into numbers?
Well,
Cat seems to think you don't have to.
sorry, the cat thing.
Yeah. Well, they say lots of things about comparables, which the CMA jump up and say yes, 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 and then they say, but then you were wrong to reject them. I mean, the Cat's view is quite pragmatic about comparables, but even though they came to a conclusion against the CMA.
But what we do say is wrong in the CMA's approach is that they afforded the comparables no weight at all.
Again, they were dismissed on a binary basis.
On a binary basis.
Yeah.
Yeah. And that is also what the tribunal held was unlawful.
Yes.
What we don't find in the judgment, we accept, is any ruling on the extent to which, as Flynn submitted, its comparators were sufficiently comparable to provide valuable evidence, or evidence that some material weight could be given to.
Yeah.
And if so, what that evidence showed about the normal rate of return for Flynn.
Yes.
And the court has the point. The tribunal never got there because it didn't need to on the basis of its prior findings. We raised grounds of appeal on them on which evidence was heard and which would need to be determined. is our short point. Just before I come to our respondents' notice, and a lot of our respondents' notice arises from that, as your lordships appreciate, I should note that the CMA made what we thought was a very odd submission in their response submissions at paragraph 21A. And this is in their written response submissions, paragraph 21A, seemed to argue that it wasn't necessary to assess the comparators Flynn put forward at all. Now, that wasn't pursued orally, and we say rightly so, but because it's there in the written materials, I do just want to say we submit it's wrong. It's the sort of approach which led to the original decision being set aside and remitted. And in fact, it's inconsistent with the CMA's previous stance in this phase of the proceedings on comparators. But I don't think I need to say any more about it. Our answer is at paragraph 16 of our reply submissions. That's page 319 of the core bundle, or electronic page 394. So finally, just a word on our respondent's notice. And I'm dealing with it here because, as your lordships know, many of the points we raise do concern comparators. For your note, it's in the bundle, core bundle 1 at tab 10, or pages 70 to 80, or electronic pages 75 to 85. And I don't know if your lordships want to just have it open while I make these very short points. So, starting at paragraph 3 on hard copy page 71, electronic 76. My lord, shall I keep going in view of...
Yeah, you keep going.
About halfway down there, we explain that these are the additional and or different reasons which would need to be determined if the court were minded to allow the CMA's proposed appeal. And then we explain that a number of these reasons reflect arguments Flynn pursued before the tribunal, but which didn't need to be determined in light of the judgment. So there are 10 reasons in this respondent's notice that follow. And they're reasons that grounds that if the CMA's arguments on its appeal prevailed to the extent that part 1 of the judgment could be set aside, these points would need to be determined, we say. The issues particularly concern comparators, not solely, but for example, item little Roman 2 on page 73, electronic 78, concerns the ROS comparators that Flynn put forward during the second investigation and at trial. That includes Flynn's returns on products other than phenytoin. So that's the issue we were just looking at in the context of CMA ground 2, little 3. There are other comparator issues at little Roman 5 on page 75, electronic page 80, 8, and 9. Now, as I've explained, the tribunal criticised the CMA for rejecting this comparator evidence out of hand, but didn't itself fill in the gap by reaching its own conclusions on that evidence. And to be clear, we aren't suggesting that this court could determine those issues on which evidence and argument were advanced, but findings not made. But we do submit that if that eventuality arose, and obviously we very much hope it isn't going to be the situation we end up in, but if it did, it would have to be remitted to the tribunal for determination if there's any possibility of the CMA's decision being reinstated, because they just haven't been properly addressed on the basis of the factual and expert evidence that we adduced.
Can I ask you a jurisdictional question? For us, do you have to establish from your respondent's notice that the decision was wrong on a point of law? That's our jurisdiction. Or is it something else? I don't think we've grappled with the question of what the standard for what's the relevant test we apply to a respondent's notice. So assume we give PTA, assume that we find prima facie some of the criticisms are justified. As rightly been pointed out, we then have a discretion as to what to do. You have a respondent's notice. It's not a, well, how do we then address that as a point of, what standard do we apply to it?
So we say these are additional and different reasons.
Or is it just part of
why
our
the
discretion as to
order-
what we do? It goes to the discretion as to what we do if we find that the appeal, if we find that the appeal is correct, we then have to ask whether or not that means the decision is resurrected.
Well, it's certainly relevant to that, as your lordship will
So
appreciate.
the exercise of our discretion as to a remedy, as to which I think we do have all the powers of the cat.
Yes. Yes, we have.
Okay, maybe that's... Anyway, don't spend time. If anyone's got any analysis that we need to take into account if we get to that point.
Yeah.
And if we get to that stage and there's a procedure people think we ought to apply, then let us know.
I mean, we weren't framing. My submission to you isn't put as a jurisdiction point, because this court has all the powers of the lower court.
You've got the Schedule 8(3) powers.
Yes. But
So I think it comes down to we have a discretion at that point, and we'd have to exercise it properly. And this might be something which would go to the exercise of that discretion.
well, grounds of appeal were advanced below a raft of evidence, and
Yeah.
so on was heard, and
Yes.
it hasn't been determined. And we do submit that isn't something that this court could possibly be asked to embark upon.
Yeah. Because there is a conceptual difference. We could find, and I'm hypothesising, I'm not giving any suggestion as to what we will or won't do, but one possibility could be that we find the CAT judgment unsatisfactory, but we still have questions about the decision.
Well, and my lord, with respect, we submit one would have to have questions about the decision, because there are effectively unresolved grounds of appeal.
Well, that would be your argument at that stage.
Yeah, yes.
Okay, all right.
My lord, I don't think I need to say more about it now, but the CMA, at least at one stage, was suggesting we hadn't raised proper respondents' notice points, and we say quite to the contrary. These are absolutely standard. My lord, I'm going to hand over to Mr. Pascoe with alacrity. Yeah. Well, we're going to just
I might just take 2 minutes, if I may, to shuffle
Just-
around.
Yes.
move ourselves.
Well, it's my speaking notes, quite an important input.
You'll probably find you can do it equally well without me.
Might try half and half, my lord, and we'll compare. I'm going to come full circle and address your lordships where Mr. Bailey began, which is on the excessiveness limb of the test. And there are three initial points, introductory points, I'd just like to make about how ground one pieces together and fits into the overall picture of the appeal. So first, my lords, a point about structure. The CMA has got three sub-grounds of appeal, grounds 1.1 to 1.3. And as Ms. Stratford said, I'm going to address first and head on the CMA's argument about its 10% ROCI WACC rate, and that's what I'll call the main economic issue, and that is the CMA's ground 1.2. I'll then come back, time permitting, to deal with grounds 1.1 and 1.3. And the reason I'm going to take it in that order, if I may, is to show your lordships that unless the CMA can disturb the tribunal's findings on the main economic issue, the other two grounds of appeal don't go anywhere, at least so far as excessiveness is concerned. And I'll explain that and expand on it. Second introductory point, focusing on the economic issue, ground 1.2, the CMA accepts that this is a rationality challenge. It must persuade your lordships that the tribunal's decision to reject...
Sorry, just so we're with you, in adjectival or narrative terms, what is the point? Saying CMA ground 1.2 doesn't actually assist me very
Apologies.
much.
1.2 is what I'm calling the economic issue, which is the ROCI WACC.
Yes, okay, that's okay.
Yes.
And they say that's a rationality.
It's a rationality challenge.
We were told the CAT says that it's a conclusory
Yes.
statement, and they say, well, here's 6 references to the decision where
Yes.
we've given evidence. I'm not certain that's a rationality.
Well, I'll deal with that, my lord. We'll meet that on its own terms. But I think Mr. Bailey actually fairly wrapped it into his overall rationality challenge. So the CMA accepts it's a rationality challenge, see paras 50 and 55E of its principal written submissions. But not only that, my lords, ground 1.2 traverses an issue which was driven very much by the experts at trial, and on which there was live evidence from economists and an industry expert who, of course, are not before this court. And as I'm going to explain, this is really a theme of my submissions. Contrary to the impression given by the CMA, the tribunal's reasons for setting aside the decision on excessiveness had their roots, had their imprint in the very criticisms put forward by Flynn's experts at trial and on which they were cross-examined. And so if that's right, what the CMA must really show is that no reasonable tribunal could have accepted those criticisms made as they were by Flynn's independent experts. And in my submission, that's a tall order. Third introductory point, my lord, Ms. Stratford has already mentioned, we have respondent notice points going in particular to our comparator evidence. Now, the relevance of that to ground 1 is that Flynn adduced empirical evidence from the market to show that the CMA's reasonable rate of return for Flynn was wildly out of kilter with the returns earned by it and other companies on similar products in the real world. And Ms. Stratford has already made points about what would need to happen to that evidence if any part of the appeal succeeded. Those are my 3 introductory points. Mr. Bailey started with the authorities on excessiveness. Now, I'm not sure there's actually anything between us in terms of what those authorities literally say. But we do seem to draw slightly different conclusions from them. In particular, there was a hint in Mr. Bailey's submissions that the authorities provided some sort of complete answer to Flynn's challenge at trial, which is that they have endorsed in any and all cases a reasonable rate of return that is equal to a company's cost of capital. So ROCI equals WACC. And just for reference, that's day 1, page 78, lines 2 to 4. where Mr. Bailey submitted the cost of capital is the reasonable rate of return. The CAT says that in liothyronine and again in Lapaterel. Now, if that were Mr. Bailey's submission, it would, with respect, be wrong. No case says that, of course it doesn't. And I'm not going to take your lordships there, but I refer you to this court's judgment in Phenytoin I, paragraph 97, which makes it abundantly clear that the reasonable rate of return and the economic approach to deciding the reasonable rate of return depends on the facts and circumstances of the individual case. I'd be surprised if Mr. Bailey and I disagreed with that level.
I think you cited Aspen, which the Commission came up with a fairly strong, robust statement in favour of Rocky. But
yes, but then went on, I think, to acknowledge that
it's all on the facts.
It's all on the facts, my lord. That's the only point I'm making and
Yes.
a need to make at this stage.
There's nothing in law which prevents an ROS approach, you say.
Or another approach. I'm going to explain. There are other approaches.
Not that meets the point, does it? Because I understood your point to be the authorities don't show that Rocky equals cost of capital. That was the point started with. Is that right?
The authorities don't show that a company's reasonable rate of return is necessarily its cost of capital.
Well, reasonable rate of return is
Yes.
not Rocky. Rocky is one way of establishing a reasonable rate of return.
Rocky is one way of
And
establishing.
it's accepted that ROS is another way.
Yes,
No
Rocky.
dispute about that.
Yes, so Rocky is a way of establishing the return. One then has to ask, is it a reasonable return? And that's where the equation between Rocky and WACC comes in, because the CMA says, well, a reasonable Rocky is the WACC. They're equal. And my simple submission is there is no case that mandates that to be the case. Of course there isn't. It's a fact-specific inquiry.
So what's your point about the CMA? So let's assume that it's all up for grabs.
Yes.
This was the approach they adopted on the facts.
Yes.
In large measure, the CAT agreed, safe for WACC, in terms of Rocky versus return on sales. And then they disagreed with them on the WACC.
Yes, there's some nuance to what the tribunal found, and I'm going to spend some time unpacking that, if I may. But the point that I'm taking is that you can't disregard all of the economic evidence given at this trial because there is some sort of legal answer to the whole point, which is that a reasonable return equals WACC.
Let's assume for the sake of argument we accept there's no absolute legal argument. It all turns on the facts.
Yes. Yes, and that may or may not be controversial between Mr. Bailey and I, but there was a hint in his submissions that there might be some sort of legal answer. Now, this is an appropriate moment, my lords, to show you para 47 of the CMA's principal written submissions, core bundle 178.14, electronic 197. And
The CMA's principal submission.
that's right.
Paragraph.
Paragraph 47, my lord.
Sorry, tab
12A.
12A.
And I show your lordships that because it acknowledges in terms the point I've just been making. It says halfway down, as explained in the decision, there are several methods to determining the reasonable rate of return. The Rocky measures profit from the capital employed in supplying a product. The ROS measures a percentage of revenues, and cost markups measure profit as a percentage of costs. And I just ask your lordships to put a pin in particular, that the acknowledgement that a cost markup is a potentially available method for measuring a reasonable rate of return. Now, my lord, if one needs further support for the fact that different measures of a reasonable return may be appropriate in different cases, and there's no legal rule or set rule endorsing one or the other, one need look no further than the CMA's original decision. Can we pull that up, please, at reference supplemental bundle, tab 2, page 60.
Sorry, can you give me that?
Yes, of course. Reference supplemental bundle, tab 2, page 16. And I think it's the same electronic pagination for that particular bundle.
16.
1616. And your lordships should see in the middle of the page, para 5.157. Do you have that? This was the CMA's original decision. It says the CMA has concluded that ROCI would not be an appropriate measure of the reasonable rate of return to calculate cost plus for Flynn's products. There's then some confidential text. The CMA considers that ROS is the most appropriate measure of return for Flynn, as the calculation of ROS does not use any measure of assets employed.
So why is that confidential text?
My lord, I'm being told from those behind me that it's not, so yeah. It may at one point have been designated as confidential. It's,
And they changed their mind, we know that.
and they changed their mind, and I'm not reopening that point, my lord. What I'm saying is there is a judgment to be made, and I'm going to show your lordships this. It was a judgment made by the tribunal after hearing many days of expert evidence on this as to what the correct approach is. That's the point that I'm making. So, my lord, let me go into the substance now. And in my submission, it is necessary to take a few steps back because the judgment under appeal sits on the shoulders of a great deal of analysis and previous judgments and decisions that have come before it. And importantly, as my Lord Justice Green might recall from the last time around, one of the reasons that the original decision was set aside is that the CMA's rate of return for Flynn was based on an economic theory, only an economic theory, of perfect competition rather than being based on empirical evidence of what is a normal rate of return for a product like Phenytoin.
Was it 6%?
Yes, so the benchmarks put forward in the original decision was a 6% ROS cross-checked by a ROCI of 8 to 12%. The benchmarks put forward in the second decision was a 10% ROCI cross-checked by a 6% ROS. That's what changed between the two decisions. And can I just show your lordships that, because it's an important point in the context of what is ultimately a rationality challenge. Original judgment, core bundle, page 518, electronic 593. And I'm going to take it from para 320, halfway down the page.
Can you just help me with the pointers which flows from this?
The point that flows from it is that the original findings in the decision were set aside as being based on a theory of perfect competition. And the submission that I'm going to make is that exactly the same methodology was put forward in the second decision. Exactly the same criticisms were levelled against it by our experts. The tribunal endorsed those criticisms and also found that the second time around the methodology wasn't sustainable, and it therefore doesn't lie in the mouth of the CMA to say that it was irrational for the tribunal to accept our experts' criticisms, the very criticisms that were accepted the last time around.
Okay.
So you'll see from para 320...
I suspect the point that's going to weigh most heavily in our minds is whether or not the CAT's conclusion that the analysis was conclusory is in fact borne out by the evidence of the WAC comparables in the decision.
Yeah, yes, I'll deal with that.
I understand the point.
Yes.
I mean, we get that.
Well, perhaps in light of that indication, I'll ask you just to read one paragraph,
Yes, of
here,
course.
which is para 323, over the page. So just for context, para 322 is addressing, you can see from the first line, the Rocky cross-check.
Yes.
And that is what was then elevated into the main benchmark the second time around. They were switched around. You had 6% ROS, I think 8 to 12% Rocky, and then you had 10% Rocky, 6% ROS. And what the tribunal says about the Rocky cross-check is at 323. And it says, we do not think that this additional work carried out by Mr. Harman is the same proponent of the Rocky in the second decision, added greatly to the overall picture. Finding a minimum return on capital for investors was merely another manifestation of using a cost-plus approach to calculate the excess and was subject to the same basic error as with finding a reasonable return on sales, of not focusing as a start point on the prices that would have pertained in circumstances of normal and sufficiently effective competition. And that, my lords, I'm going to show you is exactly the point that our experts spent many days articulating in evidence. Now, as your lordship knows, Flynn's reasonable rate of return in the first decision was found to be 6% ROS. And what that means in practice is for every £100 of sales that you make, £6 of those sales may be profit, may be margin. And as I've said, the original decision was set aside and remitted on the basis that it was based on economic theory and perfect competition. The CMA went away and came back, as I say, with this flipped over analysis that put Rocky at the forefront. And that produced a reasonable rate of return, and this is not controversial, of a 2% ROS. So you can mathematically switch between these metrics. So a 10% Rocky equals a 2% ROS. That's from the decision itself, decision table 5.13. So now for every £100 of sales Flynn makes, it's allowed to make £2 of profit. And that's a result of the process of remittal that was ordered because the first finding, the £6 of profit, was found to be based on an economic theory premised on perfect competition. So that was a troublesome outcome of the remittal process. And we got to that outcome in my submission because the CMA remittal decision does two things, each of which is crucial to understanding how the judgment under appeal was reached. The first is that the CMA changed tack, this is the U-turn, between its first and its second decision and decided to use a return on capital-based measure, a Rocky-based measure for Flynn, and to define capital narrowly for that purpose. Now, that was a measure, and I'll expand on this and show your lordships how it came up in the trial, which set Flynn up to fail, because Flynn has barely any capital as defined in the decision. Thus, the CMA restricted Flynn to earning a return on a tiny subset of its costs. That's the first thing that happened in the remittal decision. The second thing that happened, and this is the point I think that my lord is interested in, is that the CMA said that Flynn's reasonable return on that tiny amount of capital was equal to its cost of servicing that capital, the WACC. So in crude and simplistic terms, and this is a simplification, its reasonable return was limited to paying the interest on Flynn's bank loans, its providers of capital. That is the so-called equation between Rocky and WACC. Rocky equals WACC. The reasonable rate of return for Flynn is equal to its WACC. And in combination, those two factors resulted in a rate of return for Flynn that was, as Ms. Stratford has submitted, absurdly low. Ms. Stratford has already explained that the simple mathematical expression of what Flynn is allowed to earn as a reasonable rate of return on top of what Pfizer is allowed to earn as a reasonable rate of return is £66,000 per year across the 4 products. That's £15,000 to £20,000 return per year across the 4 products. And, my lords, that return, it's not return in the conventional sense that the man on the street might understand. That return is to pay the interest on Flynn's bank loans. That's the return. I don't think Miss Stratford gave the reference to the 66,000 figure. If your lordships want it, it's Deconning 7, paragraph 28, core supplemental bundle, pages 177 to 178.
Core supplementary bundle.
177 to 178. Now, both of the points that I've mentioned, restricting Flynn to earning a percentage return on a tiny subset of its costs, and equating the cost of capital with Flynn's reasonable return, were the subject of criticism by our expert economist, Mr. Deconning, and our industry expert, Mr. Williams. And they were both cross-examined and questioned in the hot tub on those criticisms at length. And this is where we get to the judgment, my lords. Can we please take up judgment, para 1062, core bundle 722, electronic 797. My lord there. Page 722, electronic 797. And at subparagraph 2, Roman 1, the judgment, in its usual way of slightly paraphrasing what the parties have said, reproduces our argument that the equation of Rocky and Wack, so Rocky Wack, didn't measure a reasonable rate of return at all. So that's argument number 1.
Give me a second. I'm just trying to reconcile the 350,000 number with the 66.
Yeah. My lord, the answer to that, there's a simple answer. The 350,000 figure is based on Pfizer's actual supply prices coming into Flynn. And because those prices are higher than the decision says they should be, Flynn's capital costs, this will hopefully become clear as I unpack it, Flynn's capital costs are higher because they're holding a higher value of stock. And so if you get 10% of your value of stock, that's 350,000 on Pfizer's supply prices. But the decision finds that Pfizer's supply prices were excessive and unfair. Now, if you adjust those supply prices such that they're sold at the reasonable rate of return, which is the world that the decision ultimately envisages, and add Flynn's reasonable rate of return, that's how you get the 66,000. So the rate of return, the 10%, doesn't change at all depending on Pfizer's supply price. But once you adjust the prices down as the decision directs, you also adjust Flynn's returns down mathematically. It may be easier, my lord, if I return back to that once I've explained exactly how capital employed is calculated in the decision. So Roman 1 records our argument, developed at length in trial, that Rocky Wack was not measuring a reasonable rate of return at all. And number 2, again, paraphrases our argument that the CMA had either misdefined Flynn's capital base, as I've said, the tiny subset of its costs, or, insofar as it could not properly be defined, had used an incorrect metric. And those 2 points were squarely an issue in the trial, and as I've said, a large proportion of the 6 odd weeks before the tribunal were taken up on them. And one then fast forwards to para 170 of the judgment, which is page 781, electronic 856.
Sorry, paragraph.
170, my lord. I haven't forgotten the stuff that comes in the middle. I just want, the point I'm making to your lordships at the moment is to trace through what our arguments were and what the tribunal's ultimate conclusions were. Your lordships will see from paragraph 170, this is a summary of the tribunal's conclusions, that it found two criticisms of the reasonable rate of return to have been made out. It starts about halfway down. It says the determination, does your lordship see that? About halfway down. The determination of the level of capital employed. This is the first point. So, first point, the determination of the level of capital employed by Flynn in the decision grossly understates the capital employed. It would follow that even if the return on capital employed were defensible, it would have been calculated by reference to the wrong figure. So that's the size of Flynn's capital base. That was Roman 1 that I just showed your lordships. But secondly, the return on capital calculated by reference to the WACC does not set out a rational basis for the rate of return derived and in any event calculates the return by reference not to the focal product but to the enterprise distributing it. And that is the point at Roman 1, that the rocky WACC is not a reasonable rate of return at all. Now, the reasons for taking your lordships through that potted summary is mainly to disabuse you of any notion that the tribunal's reasons for setting aside the decision on excessiveness had no foundation or imprint in the expert evidence and analysis that it heard. Both points were front and centre at trial, and we spent many days, if not weeks, on them. Now, let me openly acknowledge, before I get into the two detailed points that Mr. Bailey challenges, that the tribunal uses different terminology in places to that which the parties used and to that which the experts used. I rather like Mr. Holmes's description of there was an ornate terminology. I think that the judgment is draped in an ornate terminology. That's certainly true. I also acknowledge, as I must, that the tribunal did not accept the entirety of what our experts said, and nor, of course, did it accept the entirety of what the CMA's experts said. And I also acknowledge that the judgment is in parts discursive, and it jumps between topics and ideas and can be difficult to follow. I acknowledge all of those things, but my overall submission is that in substance, the tribunal accepted our experts' core criticisms of the decision following their cross-examination at trial, and there's no reason to disturb the tribunal's findings based on that process. Certainly it cannot be said that our own experts' criticisms, in brackets having been accepted in the very first trial, were so irrational that no reasonable tribunal could have accepted them. Now, my lords, Mr. Bailey made two more detailed points. The first is that the tribunal acted irrationally in adopting a different definition of capital employed than that used by the CMA and by Flynn. That's the first point. And the second point is that the CAT acted irrationally in rejecting the CMA's theory that a company's reasonable rate of return is equal to covering its cost of capital and no more. I'm going to address those 2 points in that order, but I emphasise at the outset that the CMA has to win on both of them. They're both independent and sufficient criticisms of the decision such that the findings of excess would have to be set aside if either one of them were right. So please can we then, my lord, begin with 149 of the judgment. So I'm beginning with the capital employed point. 149 of the judgment, page 770, electronic 845. Your Lordships will see that the judgment sets out the CMA's decision at the foot of the page. So just to orient ourselves, which explains that in order to assess Flynn's reasonable rate of return, the CMA first needed to estimate Flynn's capital employed. That's because it's using a return on capital employed approach. And then it added Flynn's WACC, i.e. the notional interest rate on its bank loans or whatever it pays to the providers of its capital, to identify the reasonable return in pound terms. Now, over the page at 150, the tribunal then sets out the findings of the decision on Flynn's capital employed. And can I just ask your Lordships to read the cited part of the decision? So, my lords, summarising, the CMA assessed the working capital that Flynn needs to sell Phenytoin, and it found there were two components of that working capital. First, Flynn had to hold a buffer stock, and the CMA assesses the cost of holding that buffer stock at £2.8 million. One sees that from the, I think it's our 5.235 as cited in the judgment. Second, Flynn faced costs, as does any other business, in extending credit to Flynn's purchasers, i.e. costs of having debtors, net debtors. And the CMA assesses that cost at £700,000. So in total, the CMA assesses Flynn's working capital as £3.5 million. And just to come back to my Lord Justice Snowden's question, the reason that the rate of return in pound terms goes down if Pfizer's input price goes down is because the cost of that stock and the value of the debt for that product just goes down because, you know, if you're paying 50% of the input price, the cost of the stock is 50%, and you have 50% less debtors. So that's how it works. Now, the result. Sorry, can I go over the page to 151 of the judgment? This is important. The judgment notes that the CMA did consider whether to include certain other types of capital in its calculation, such as Flynn's human capital, its skills, its workers, but it decided not to do that. That's just a statement of what's found in the decision. So the result was that Flynn was limited to a capital employed figure of £3.5 million. And just mathematically, £3.5 million is obviously much lower than Flynn's total costs of supplying Phenytoin, which were some £75 million over the relevant period. And we'll keep coming back to that.
That's a figure for the acquisition costs? Is it 75 million? Over the
75 million is total operating costs, which includes
The input price from
the input price. Absolutely.
most of it. is the input price.
Yes, yes, that's right. That's right. Now, what's the significance of that, Your Lordships may ask? Well, it reflects the fact that Flynn, as a business, doesn't make large, it doesn't really make any capital investments. It's not running factories or installing infrastructure. It's a business driven by people with skills, both in selling medicines, but also in complying with all of the regulatory obligations that come with that. And that just can't register in this type of analysis.
Can I just ask you, in the decision, we have a detailed analysis of the negotiations leading up to the Pfizer-Flynn agreement in 2012. We've then got an analysis of the role that Flynn played in that in terms of what it meant to be an MA holder, the extent to which he was actually administering the drugs as they went through, because they went through somebody else, another, and so on. Is there any challenge to that analysis of Flynn as playing a minimal role with very low risk?
I think that comes back, my lord, in the second part of the analysis, which is whether the reasonable rate of return is limited to just servicing your bank loans and nothing more.
Right.
We do have a respondent's notice to that effect.
Yes.
My submission is going to be that we don't need it.
You don't?
We don't need that point.
You don't need it?
We don't need that point. Right. We don't need to successfully challenge the findings in the decision that Flynn faced limited risk. It didn't say it faced no risk, it said it faced limited risk. But the sole point I'm making at the moment is when one asks, well, why do you have a small capital base like that? It's just because Flynn it's not a capital heavy company.
No.
And that of course is why in its first decision, the CMA said, we don't think Rocky is appropriate for Flynn, we're going to use Ross. Now, this was exactly the point that was made to the tribunal by our two experts in their reports and in cross-examination. Sorry, I should just add the punchline, which is obviously if you start from a very small capital base, your permitted returns under this model are always going to be correspondingly small. That's the point made by the experts that I'm now going to show your lordships. So could we start, please, at core supplemental, tab 21, page 188.
That proposition just flows mathematically, doesn't it?
Does, yes. Yes, exactly right, yes.
Good. Punchline of this is ... What does this actually go to as a... Where it's a response to the CMA.
Yes.
They're wrong because, in view of this.
Yes, they're wrong because a capital employed approach doesn't capture the assets that drives Flynn's business and limits it to an arbitrarily low return.
But the CAT decided that the ROC approach, which is the return on capital employed, was the right approach, not ROS. Are you trying to resurrect the ROS approach in front of us?
We have a respondent's notice point to that effect as well, but to flag where I'm going, what actually happens, I think Mr. Bailey and I probably agree on this, is that the tribunal endorsed the wrapper of a Rocky approach. They endorse a Rocky approach. Yes. But what they actually apply is what we would both call a costs markup approach. That's where the tribunal ends up.
Well, they define the capital employed
as the costs,
including the operating costs.
Well, as the operating costs. Yes. Yes. So it's a cost markup.
They purport to be applying a rocket approach to it.
Yes, that's right. And if there's I'm just going to address this head on. If there's a vice in the judgment, it's that they describe what they're doing as a Rocky approach when they've defined capital in a way that really they should be calling it a costs markup approach.
They haven't actually applied a Rocker approach. Well, they've erred in doing so because they've mistaken capital employed for operating costs or vice versa.
Well, we would not dispute that they haven't used the terminology that our experts used. Our experts wouldn't have called that a Rocky approach. They would have called it a costs markup approach. The submission that I'm going to make, just to preempt it, is that where they get to, aside from that point of economic terminology, is a rational one and was based on what our experts were telling the tribunal. So I was just going to show your lordships what our experts said. And I think I called up Core Supplemental Bundle, tab 21.
It may be easier. I mean, I think for my part, if you can explain to us why you think the CAT was right and what part of the judgment, and then if you want, I mean, some of this can be deduced almost by logic rather than evidence.
Yes. Yes, okay. Well,
It'd be helpful, I think, just to get it clear in my own brains, just to know which bits of the judgment you're now agreeing with.
yes, okay. So, my lord, let's start then, if I may, with judgment para 156, which is at page 775, electronic page 850. And the point that the tribunal makes here is the obvious one, and obviously not disputed on its face, that £3.5 million was a gross understatement of, now I'm paraphrasing, of Flynn's costs of supplying phenytoin.
Yeah.
There was a big difference between what it actually cost to supply this product and what went into the CMA's bucket of capital employed, and that the expert evidence that I was going to show your lordship made exactly that point, the disparity point. And of course, my lords, this is actually a case-specific point in this sense. One can have companies, a port operator would be a good example, where your bucket of capital employed will actually be what's driving the business, what's driving the operations, will account for the majority of your costs of doing business. Flynn just wasn't like that. But the tribunal had a second, slightly more involved reason for rejecting the CMA's approach, and that appears at para 148 4 of the judgment, which is page 765, paper 840, electronic.
I'm sorry, again, paragraph number.
Paragraph 148, sub 4. My lords, I see the time. Might I just take you through this paragraph and then finish? Now, this is a slightly involved paragraph, but the point in a nutshell is that the CMA's approach produces arbitrary results depending on whether a business is set up with a high or a low level of capital. You can see that the tribunal begins with the uncontroversial statement, this is sub 4, that many products can be produced at similar cost using different methods, including using different factors of production. That's of course right. The tribunal then says it is or ought to be tried that any judgment on excessiveness should not depend on the method of production chosen by the entrepreneur. And we then go over the page. There's a number of sub-paragraphs. And sub-paragraphs 1 and 2 introduced a stylized and somewhat whimsical example, which was discussed with the experts at great length in the hot tub. And the example involved a thought experiment about two coffee shops. The first coffee shop, you can see from sub 2, invests heavily in machinery to make and serve your coffee, and sells coffee from its shop at a cost of $110,000 per year, with $100,000 of that spent on machinery and $10,000 of that spent on labour. The second coffee shop, the vanilla coffee shop, is the opposite. It invests heavily in its staff and they're therefore labour costs, but not in machinery. It too sells coffee at a cost of $110,000 per year, a total cost, but its costs are geared towards labour and not machinery. And the tribunal's concern was that the CMA's approach allows robo-coffee shop a much higher rate of return than vanilla coffee shop. And at Roman 3, your lordships will see that this was explored, as I say, at great length with the experts. And our economist, Mr. de Koning, who is cited below Roman 3, drew parallels between the tribunal's concerns and his own concern with the CMA's approach as it applied to Flynn. And the concern in both scenarios is that the CMA's approach restricts the company's return to a subset of its costs, those which are called its capital costs, which can produce very low levels of permitted return if the company doesn't happen to have many capital costs. Now, my lord, nothing turns on the whimsical use of robo-coffee shop.
It's all covered in Annex 5, isn't it?
It's covered in Annex 5, and then it's a rather elaborate piece of the judgment. But as I say, nothing really turns on the coffee shops or their descriptors. The point is a universal one, which was made at length by our experts, that a ROCE measure as conceived by the CMA essentially discriminates against businesses which produce revenue through costs other than capital costs. Now, just finishing off before lunch, the tribunal didn't accept all of Mr. de Koning's evidence on this point. And this goes to my Lord Justice Zacaroli's point. It rejects, underneath the citation I've just shown you, Mr. de Koning's conclusion that the ROCE approach was therefore inapposite for a company like Flynn. But it did accept the fundamental criticism. It said, in the same passage, if the ROCE test for a reasonable rate of return were to differentiate between two equally efficient enterprises that have similarly deployed different factors, simply deployed different factors of production differently, then we accept that the test is unusable for the purpose of the excessive limit. And that may be an appropriate moment, my lord, to draw stumps.
For my part, could I have the references to the expert you were going to give us?
Yes. So the first reference I was going to give your lordships is to the position paper of Mr. de Koning. The position papers were summaries of the reports, which is core supplemental, tab 21, page 188. And then I was going to give, I'm reminded, paragraph 22A. And then I was going to give your lordship the reference to what Mr. de Koning said in his live evidence, which is reference supplemental bundle, tab 59, page 1594, and also to what our industry expert, Mr. Williams, said in his fifth report at para 14, ref supplemental bundle, tab 36, page 1346.
Ten past 2.
Thank you.
All the rights available.